All right, good morning, ladies and gentlemen. We are going to begin with our state all-purpose calendar. Morning, Mr. Ham. All right, Mr. McLean.
Good morning, Your Honor.
All right, Ms. McVicky. All right, perfect. All right, good morning. As I was saying, my name is Judge Law, and this is the state all-purpose calendar for today, June 27, 2024 at 9 a.m. We are going to begin with our misdemeanor cases. This is essentially a plea and arraignment calendar. We may also address other issues such as bond modifications and probation revocation cases. If you are a defendant who presently is in courtroom 2, please remember that you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Mr. McLean, good morning. Who are we beginning with, sir?
Good morning, Your Honor. We will start with position number 8 and 9, Mr. James Dover.
Okay. Mr. McLean, is that your client?
It is, Your Honor, he is, and I believe that's down as a negotiated plea.
All right. This is State versus James Dover, case number 21 CR 543C. Mr. Dover was originally accused of battery, family violence, cruelty in the third degree, and hindering a person from making an emergency phone call. Charges were from February 7th, 2021. His second case is a bench warrant, 24 FTA 772 from November 2nd, 2023. Mr. Dover, you've been advised of your right to remain silent, and your attorney is Mr. McLean. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Ham? Yes, sir. What's the recommendation?
Yes, Your Honor. For position number 8, state's recommendation for count 1 battery is 12 months to serve 32 days, credit for the time served 16 days, the balance to be served on probation, to complete 40 hours of community service, to complete a family violence intervention, impact plan, FVIP class, 1 parenting class, and for the defendant to have no firearms. For position 2, cruelty to children in the third degree, state's recommendation is 12 months probation to run concurrent with count 1. For count 3, hindering person while making an emergency telephone call, the state's recommendation is 12 months probation to run concurrent to count 1, Your Honor. As it relates to position 9, the state will move to null pros, position 9.
Mr. McLean, do you so stipulate to factual basis, venue, and ID, and does your client accept these terms?
For the purposes of the plea, we do so stipulate he does.
All right. Mr. Dover, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you or inducing you to take a plea today?
No, ma'am.
Has it been explained to you that if you decide to plead to these charges, you would have to give up your constitutional right to a trial before a judge or a jury? You will not get the opportunity, excuse me, to confront your accuser, challenge the evidence brought against you, and have the state carry the burden to prove the charges against you beyond a reasonable doubt.
Yes, ma'am.
How do you plead to 1 count of battery, family violence, cruelty in the third degree, and hindering a person from making an emergency phone call? How do you plead to these 3 charges, sir?
Guilty.
Excuse me. On the battery family violence charge, your sentence is going to be 12 months to serve 32 days, credit for time served 16 days. The remainder of the time will be served on probation. Today's Thursday, so you will report to probation on Monday, which will be July 1st, I believe. Did I have the right date?
That is correct.
Okay. So it'll be July 1st, 2024, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of community service with any nonprofit agency that's not a church and not a school. You will begin with a minimum of 5 hours per month and 5 hours every month thereafter. You will also enroll in a domestic violence intervention program, and that must be done within 45 days of being released. You will continue to attend those classes under that program until you get your certificate, which you will then present to your probation officer. You're also to complete a parenting class and not be in possession of any weapons and firearms. So please be sure that you complete these classes. Let me see. Oh, on counts 2 and 3, each of them will be 12 months probation, and those sentences will be concurrent to count 1. Any questions?
So, no more jail time here, correct?
If you have no other cases holding you at the jail, that would be correct. You'll be released within 24 hours, and your bench warrant is not going to be null pros or dismissed.
Thank you very much.
All right, good luck. Thank you.
Thank you.
Next case, please.
Next, we could go to position number 6, Jordan Crow. Third row, you can just go back. Jordan Crow.
All right. Mr. McLean, that's your client as well, correct?
Yes, Your Honor, I have that down as negotiated plea from yesterday.
Okay. Mr. Jordan Crow is 24 CR 3744Y, accused of criminal trespass and misdemeanor possession of marijuana from June 12th to 2024. Mr. Crow, you've been advised of your right to remain silent. Your attorney is Mr. McLean. May I place you under oath for purposes of the plea? Mr. Crow?
Yes,
Good morning.
Good morning.
We are about to begin a plea hearing. May I place you may I place you under oath?
Yes, ma'am.
Raise your right hand. I can't see it, so you may have to raise it higher. Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. May you place your hand down? Mr. Ham, yes, sir?
Yes, Your Honor, just to bring to the court's attention, there is an add-on case in addition to that. It's 22 CR 008207Y.
207Y. Okay.
And he will be making a plea to both cases today, Your Honor.
All right. Can you tell me what are the charges in the 8207Y?
Yes, Your Honor. For count 1, it's fair evasion. Count 2 is criminal trespass. And count 3 is obstruction of a law enforcement officer.
Okay. All right. So he's addressing 2 cases and a total of 5 charges. All right.
Yes, Your Honor.
What's the global recommendation?
Yes, Your Honor. Under case number 24 CR 003744Y, for count 1, possession of marijuana less than 1 ounce, the state will move to null pros that count. For count 2, criminal trespass, the state's recommendation is 12 months to serve 32 days, credit for time served 16 days, balance to be served on probation, and to stay away from all MARTA locations. For the add-on case 22 CR 008207Y, count 1, fair evasion, the state's recommendation is time served. Did 4 days in jail for this count.
All right.
For count 2, criminal trespass, the state's recommendation is 12 months probation to run concurrent with 24 CR 003744Y and to stay away from all MARTA locations. For count 3, obstruction of a law enforcement officer, the state's recommendation is 12 months probation to run concurrent with count 2 and to pay a $300 fine.
All right. So on count 2 of the position 6 is 32 days to serve 16 days, balance probated and stay away from all MARTA?
Yes, Your Honor.
Okay. Mr. McLean, are these the terms to which your client has agreed?
They are, Your Honor. I noticed that in both cases overall, there is a fine. So hopefully he'll be able to get some employment, pay off that fine as quickly as possible. And we would ask the court to consider it on reporting or termination. He will be staying away from MARTA, but that's not as a condition of probation, that's not something that requires activity. It just requires staying away. So hopefully he could go to non-reporting or termination after paying the $300.
What's his suspension status? Does he have a permanent ban from order?
That's what the police report said. So he does understand, he completely understands staying away from MARTA, period.
Okay. Mr., and you stipulate to the factual basis venue and ID, Mr. McLean?
For the purpose of the plea, we do.
All right. Mr. Crowe, have you consumed any medicine or alcohol recently?
Not that I'm aware of.
All right. So you don't know whether you consumed or drank any alcohol or consumed any medication?
Not this morning, ma'am. No, not that I'm aware of.
All right. I'll take your plea when you're more certain of your answers.
I mean, I do take medication, but I mean, I haven't taken anything this morning. I mean, I haven't.
Okay.
Um,
That would be a more affirmative response.
My apologies.
And have you understood what's going on in your case so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Has anybody forced you or induced you to plead guilty today?
No, ma'am.
And has it been explained to you that if you decide to plead guilty to the charges in these two cases, you would have to give up your constitutional right to a trial in front of a judge or a jury? You will not have the opportunity of going back to court with your attorney to present your defenses, arguments, and mitigating factors, to confront your accuser, to challenge the evidence that will be brought before you, and to have the state carry its burden to prove the charges against you beyond a reasonable doubt.
Yes,
Are you
ma'am.
prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass from June 12, 2024?
Guilty.
The possession of marijuana charge is going to be null prost. How do you plead to fare evasion, criminal trespass, and obstruction of a law enforcement officer?
Guilty.
On position 6, criminal trespass, your sentence is 12 months to serve 32 days, credit for time served 16 days. You will be placed on probation to monitor that you comply with the stay away provisions from all MARTA property. You are not to return to any of the MARTA buses or train stations. You're to stay away from all its property, including sidewalks, parking lots, their bathrooms, and any of their facilities. Do you understand, sir?
Yes, ma'am.
With regards to 22 CR 008207Y, on the fare evasion, it's time served of 4 days. With regards to the criminal trespass, is 12 months concurrent to the trespass charge from the prior case. And with regards to the obstruction of a law enforcement officer, is 12 months probation concurrent to the criminal trespass charge from the prior case with a $300 fine. You will report to probation every month beginning July 1st, 2024 before 3 p.m. And the probation office is located at 132 Mitchell Street in downtown Atlanta. You will also begin paying your $300 fine with a minimum payment of $20 in the first month and then $50 every month thereafter. I will waive your probation fees for up to and including September of 2024. So you start paying probation fees from October 1st, 2024 onwards. It is your responsibility to make sure that you retain an occupation so that you may pay your fines and fees and make sure that you do not get arrested again. Otherwise, probation is authorized to issue a warrant. Thank you.
Good morning, Your Honor.
Morning, Ms. Debbie Milton.
I have Miss Deborah Miss for the interpreter, the young lady right here. That is position number 21.
What?
I need a breakout, please.
21. And is that Ms. Vigiletti's case or Ms. Atate's?
Yes, Judge, and if the interpreter is here, I'm happy to enter a breakout and, oh, fantastic. I'm gonna log in with my phone and step into the other room and we can have a conversation.
All right. Ms. Champion, as soon as you let Ms. Vigiletti in onto the Zoom session, please place her, Fulton ACDC, and Mr. Thang into a breakout session. All right,
Yes, ma'am.
thank you. All right, courtroom 2, who do we have next, please?
We can go to position number 7, Mr. Michael Dodds.
Your Honor, while that's being prepared, if I might announce, on positions 1 and 2, my client wants that to be non-negotiated. He is also on the probation calendar, but he will mention why he needs a non-negotiated request on number 1 and 2.
All right, but right now we have Michael Dodds, case number 24 CR 3729H, accused of loitering and prowling, willful obstruction of a law enforcement officer, and criminal attempt to commit a misdemeanor. Mr. Dodd, you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a non-negotiated plea, was that correct?
Correct, Your Honor.
All right, so Mr. Dodds, the state is going to make a recommendation as to what the sentence should be if you decide to plead guilty, and your attorney is going to give me an alternative recommendation. I will let you know which recommendation I will accept before you have to enter any kind of plea. For purposes of the hearing, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Ham?
Yes, Your Honor. For count 1, loitering and prowling, the state's recommendation is 12 months to serve 90 days. Credit for the time served 16 days. The balance to be served on probation, to complete 40 hours of community service, and to stay away from 850 Mercer Street, Southwest, Atlanta, Georgia. To have no further contact with Stephen Carr. For count 2, willful obstruction of a law enforcement officer, state's recommendation is 12 months probation to run concurrent with count 1 and to pay a $300 fine. For count 3, criminal attempt to commit a misdemeanor, the state's recommendation is 6 months probation consecutive to count 1. Your Honor, the factual basis.
I'm sorry, I was just writing down the word consecutive. Okay, go ahead.
Yes, Your Honor. The factual basis of this incident happened when the defendant was caught removing wires from the property belonging to Mr. Stephen Carr. Once the police arrived on the scene, he ran away from the police. This particular defendant has an extensive history. He has a history of 37 cycles. Some of his most recent convictions that are relevant to this particular facts of this case is theft by shoplifting out of East Point, which he pled guilty to on November 18, 2022, which incurred a ban from East Point. He was also convicted of felony burglary to the 2nd degree out of Fulton County under 18 SC 161069. That happened on October 29, 2018. He was also charged with willful obstruction of a law enforcement officer, possession of tools for commission of a crime out of Clayton County under 18 CR 00449. That happened on February 21st, 2018. And he was also charged with theft by shoplifting out of Fulton County, 17 CR 008789B on March 22nd, March 22nd, 2017. So based upon his extensive criminal history with committing the same or similar acts, Your Honor, we believe that this sentence is appropriate.
Thank you, Mr. Ham. Mr. McLean? Yes, sir.
Your Honor, Mr. Dodds would like to ask the court to accept his plea and to give him a sentence that does not involve more than about 10 extra jail days on account of he feels he will lose his job. If it goes past that, he's afraid the position won't be held open for him.
What does he do?
Let's see, that was with the auto place, I believe it was, Stevens Garage in, I believe, Noonan, Georgia. Your Honor, in this case, the obstruction, of course, involves fleeing. He tells me that when I realize we're not trying the case, but he just wanted to put this in there that When the officer presented himself, he had his gun out and Mr. Dodds was scared and ran. It was an instinctive, impulsive, quick thing because he had been shot once before and it just triggered a physical response in him. He saw that gun and thought, oh my gosh, I'm going to be shot. And within a few seconds, that was over with and he was taken into custody. He had touched some wires. He says, I wasn't going to steal the wires, but I did pick them up. This is over by, well, this was on some property that was over by the belt line. And there were some wires there. They're probably going to be used for some future construction or something. You know how sometimes wires will be on the ground for future use. They were rusty looking. He says, I wasn't going to steal them, but I understand why he charged me with what he did. And so he'd like to take responsibility. But if there's any way that he could do no more than 10 extra jail days, he could probably keep his job.
So presently, the state is requiring him to serve 29 days. Would that
Correct.
be correct?
That's correct.
So what would the numbers be if it's 10 extra days?
Let's see, for that to be let's see. For something, for X minus 16 to equal 10, that would have to be 26 minus 16. So double 26, instead of 90 days, it'd have to be 52. So we take half of 52 equals 26. 26 minus 16 would be 10.
I'm very comfortable with your algebra, Mr. McLean. So,
Okay.
Mr. Ham, I do understand Mr. Dover's significant criminal record history. He presently has a $2,500 good bond. It's not the first time I'm addressing this case. Any specific objections to the defense recommendation?
Yes, Your Honor, based upon his repeated criminal attempts to steal, the state does object to the defense's recommendation.
All right, thank you. I'll reduce the jail time, but the requirement of the 40 hours of community service will be increased to 240 hours of community service. Plus, there is a $300 fine for the loitering and prowling, in addition to the $300 fine for the criminal, for the willful obstruction, and he's on probation for a month and a half. Is that something you'd like to consider?
Yes, Your Honor, definitely.
Mr. Dodds, do you understand what's this court's recommendation?
Yes, Your Honor.
And you, instead of 40 hours, you'll be doing 240 hours of community service, which means that in addition to your regular job, you will have to do a minimum of 40 hours of community service per month.
Yes, Your Honor.
All right. The state's objections noted. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
Mr. Dodds, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in your case so far?
Yes, Your Honor.
And are you satisfied with your legal services?
Yes, Your Honor.
Are you being forced, or is anyone inducing you to take this offer today?
No, Your Honor.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial before a judge or a jury. You will not have the opportunity to go back to court to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state carry the burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of loitering and prowling, one count of willful obstruction of an officer, and one count of criminal attempt to commit a misdemeanor?
Guilty, Your Honor.
Your sentence is going to be 12 months to serve 52 days. Credit for time served 16 days. According to your attorney's math, you have an additional 10 days to serve at the Fulton County Jail. The remainder of the time will be served on probation. You report to probation on Monday, July 1st before 3 p.m. Failure to report will result in your probation being revoked and you serving the rest of the year and a half in jail. While you're on probation, you are to complete 240 hours of voluntary community service. And you can do that at any nonprofit agency that's not a church and not a school. You will begin with a minimum of 40 hours per month and for minimum of 40 hours every month thereafter. You're to stay away from, there's also an additional imposition of a $300 fine for the loitering and prowling charge. At all times, you're to stay 200 yards away from 850 Mercer Street in Southeast Atlanta and not have any contact with Stephen Carr. Stephen Carr with 2 R's. For the willful obstruction of an officer, it will be 12 months probation concurrent with count 1 and an additional $300 fine. So that's a total of a $600 fine. With regards to count 3, that's going to be 6 months consecutive to count 1. And that means that you continue to report to probation for up to 18 months, less 16 days. That's 26 days, I beg your pardon. Sorry.
And Your Honor may have mentioned July 1st, but his release date with 10 extra days will be Sunday, July 6th.
You're absolutely right. So his release date is July 6th.
That's a Sunday.
Okay, so he'll report on July 7th before 3 p.m. at 132 Mitchell Street.
Or I might even be a day off. If July 7th is the Sunday, then July 8th would be the Monday. That's correct.
Okay,
Right.
all right, that's okay. We all make mistakes with numbers, Mr. McLean.
Okay. Very good. That's everything. Thank you. Good evening.
Deputy in courtroom 2, do we have a Mr. Dontarius Copeland in the courtroom?
No, Your Honor.
Okay, thank you. Just let me know when he appears. Thank you. Next case in courtroom 2, please.
We can go to you can go to position number 1 and 2, Mr. Craig Berry. He's also on the probation calendar. Position 1 and 2.
Okay, thank you. Miss Allen, are you? Oh, there you are. Okay, great. Thank you.
That will give me an answer.
Miss Allen, may I place you under oath? Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Kirkberry, we have a probation revocation matter before we address the cases that are relatively new. So let's address the cases in which you were convicted. Case 23 CR 4478H. This is State versus Kirkberry, in which Mr. Berry was convicted of 1 or more theft by shoplifting offenses. For his position 2 on the revocation calendar, that's 24 PV 1037. And this is an alleged probation violation. You have been advised of your right to remain silent, and your attorney is Mr. McLean. Ms. Allen, why has the state, excuse me, what was his conviction? What was he required to do? And why is the state seeking a revocation?
Your Honor, he was sentenced to probation for the charge of shoplifting. He was required to stay away from the incident location, complete a shoplifting course, as well as complete 30 hours of community service. He has failed to provide our office with completion of the 30 hours of community service. He's failed to provide documentation of completing the shoplifting course. It's 141 days remaining on his case. He has been in custody since June 18, 2024. At this time, Your Honor, we're asking for the defendant to be allowed to continue on probation to complete those conditions.
All right. Mr. McLean?
Your Honor, I believe there are additional cases on calendar that we would be dealing with today as well on 1 and 2.
Do you have any objection to him continuing on probation?
We have no objection to that, Your Honor. No.
All right. This will be recorded as a probation violation. He will continue on probation. He will be reporting twice a month. And he will report to probation twice a month until he has presented his anti-theft class certificate, which must be completed, which we must enroll within 30 days and complete. He will also need to complete his 30 hours of voluntary community service, and that must be completed within 30 days of being released. And after he has completed the shoplifting class and the 30 hours of community service, then his probation may resume to once a month. So, Mr. Berry, for this shoplifting conviction, you'll be reporting to probation twice a month, beginning whenever you're released from after we address your other cases. And it's twice a month until you finish the anti-theft class and the 30 hours of community service that you were required to complete before. Okay. Moving on to position 1 and 2 on the SAP calendar. Mr. Kirkberry has got a new charge for theft by shoplifting, but this appears to be from December 3rd, 2022. And this is case 22 CR 8118H. I guess there was another shoplifting case that was not addressed previously. Mr. Kirkberry has also got a bench warrant from February 27, 2024. All right, Mr. Berry's already been advised of his recommendations. He's been advised of his rights. And Mr. Berry, may I place you on the oath for purposes of this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Mr. Ham, with regards to this other lingering shoplifting case from Mr. Berry's past. Yes, sir. What's the recommendation?
Yes, Your Honor. Actually, he has two additional.
Oh, yes. I'm sorry. I should be reading Ms. Falk's recommendation. So you're absolutely right. He has the case 22 CR 8118H, theft by shoplifting from December 3rd, 2022. And then he has this new case, 24 CR 1959H, one more count of theft by shoplifting. And what is this SG 721402-23? What is that?
Your Honor, that case number is 24 CR 004142H.
Give me that number again, 24 CR?
004142H.
Okay. So we are addressing a total of 3 new open cases.
Yes, Your Honor.
Okay. And go ahead. I'm ready for your recommendation.
For the first case ending in 1-8, the state's recommendation is 12 months, served 60 days, credit for the time served 13 days, balance to be served on probation, to stay away from the Family Dollar at 1723 Lakewood Avenue to take an anti-theft course, complete 40 hours of community service, and to pay a $500 fine. For the case ending in 5-9, theft by shoplifting, state's recommendation is 12 months probation to run concurrent with the 1-8 case number, to stay away from Chevron Gas at 556 Northside Drive, Atlanta, and the Family Dollar located at 1723 Lakewood Avenue. For the case ending in 4-2, state's recommendation is 12 months probation to run concurrent with the 1-8 case, Your Honor.
All right. I'm looking at the notes from Ms. Falk. It appears that you're asking for consecutive on 1959H. Has that been changed?
As it is consecutive.
Okay, so it would be up to 2 years of probation for these
Yes, Your Honor.
2 shoplifting cases.
Yes, Your Honor.
Okay, with additional jail time. Understood. Thank you. All right, Mr. McLean?
John, this is a very serious matter to Mr. Berry. He understands about the probation and his obligations there. 3 shopliftings, Your Honor, will make the 4th if there ever is one. Even for a piece of bubble gum, it'll be a felony. We've had a heart-to-heart talk about this. He understands the seriousness of it and is primed to do the correct thing. He agrees to the terms. Your Honor, he would like to ask the court to consider the extra jail time. Let's see, the calculation right now from the state's recommendation would be 60 divided by 2 for good behavior would equal 30, minus 13 would be 17 extra days. And we put that down as a negotiated plea, Your Honor. We thought that's what it would be. This morning, he tells me that there is something going on with his mother's health and that we should, he'd like to ask the court to consider less than the 17 days down to as few as 0 on the extra jail days on account of the health of his mother is bad right now. And that is making him feel quite anxious. He does understand that he's going to take an anti-theft class. He's going to do community service, and he's going to pay a not unsubstantial, whichever is the good word, fine.
All right. Miss, I'm looking for my pretrial officer. Do we have Miss Bostic? Is she at the turn?
Judge.
Yes, good morning. May I have Mr. Kirk Berry's GCIC?
Yes, Judge, I'm finishing going through it. Judge, he actually has a total of 53 cycles. He has at least 4 felonies going back to 95. Most recent is a 2016 firearm by a convicted felon. I already see 3 theft by shoplifting, even though 1 is in the 90s. It's in 23, 21, and 95. He has a history of probation violations, FTA in 2015. History of, I'm sorry?
No, understood. That's all I said. That's good. Thank you very much. Mr. McLean, your client has well passed the number of shoplifting convictions. The fact that these new charges should be felony charges goes to show that the district attorney's office did not want to pursue it as a felony, as they have a right to do so, and instead was willing to let them be a misdemeanor.
Okay.
So, any other argument for reducing jail time other than the unverified condition of his mother?
That was it, Your Honor.
All right. Mr. Kirk, you are 58 years old. You have over 53 arrest cycles. You are already on probation for shoplifting, which you've already violated. And now I'm addressing 3 new shoplifting convictions. You absolutely do not qualify for any kind of reduction of jail time. Since I've already ruled on your probation case to allow you to continue on probation, because I've half a mind to simply just revoke that probation and have you complete the rest of the 114 days in jail. But I'm not going to do so because I've already made that decision. But we're going to address this one. The state is asking for 60 days credit for time served 13 days. Under these provisions, you have 17 more days to serve at the Fulton County Jail. And I'm going to agree with that, although every instinct in me tells me that you should actually just stay in jail for the entire year. All right? So given the circumstances where you have to serve additional jail time, you'll be on probation for 1, 2, 3, now 4 cases. Mr. McLean, would your client like to move forward with a plea?
He would, Your Honor. The release date calculated with that would be July 14th, and he will do his best to complete all requirements as quickly as possible upon release.
Mr. Kirk, have you consumed any medicine and alcohol?
No, ma'am.
And Mr. McLean, I'm so sorry, you stipulate to the factual basis, venue, and ID for all 1, 2, 3 cases?
Yes, Your Honor, for the purposes of the plea, we do.
Thank you. And are you satisfied with your legal services?
Yes, I am.
And is anyone forcing you, inducing you to enter this plea today for these 3 cases?
Oh, ma'am.
If you decide to do so, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to go back to court with your lawyer to address a trial by judge or by jury, to be able to present your own evidence, to challenge the evidence brought against you, to present your defenses and arguments and have the state carry its burden to prove the charges against you beyond all reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
In case 22 CR 8118H, how do you plead to one count of theft by shoplifting?
Yeah.
In case 24 CR 1959H, how do you plead to one count of theft by shoplifting?
Guilty.
In case 24 CR 4142H, how do you plead to one count of theft by shoplifting?
Guilty.
Your probation, your sentence is 12 months to serve 60 days, credit for time served 13 days, which means that your release date will now be, what was that, Mr. McLean? July
I believe-
15th?
I believe July 14th would be 17 days from today.
All right. So, Mr. Berry, as soon as you complete the 17 days, you must report to probation, Fulton County Probation, before 3 p.m., before July 20th. Do you understand?
Yes, ma'am. Yes, ma'am.
So you would have to report either on the you'll have to report on the 18th, the very next day. And remember, you have to report to probation twice a month in order to do the anti-theft class and
Okay.
the community service for that probation case.
Okay.
By the way, those do not count towards the new sentence. They do not count.
Okay.
Right. Yeah, you double credit.
Yes, ma'am.
Do you have any questions when I say they do not count to your new sentence?
Understood.
What does it mean?
That means that I have to continue on reporting after I can complete that first probation violation reporting.
That means that you have to do not one, but two anti-theft classes.
Okay, okay. Two people.
And that the 30 hours of community service is separate, and then the new community service hours are separate.
Okay. then.
And if you violate any of those conditions, you are absolutely going to prison to serve out the rest of the 2 years probation.
Okay, understood now.
So please make sure that your mother has the proper care before you take off to prison if you violate this probation.
Yes, ma'am.
As I was saying, for the case ending in 8118H, your sentence is 12 months to serve 60 days, credit for time served 13 days. This will be a new probation, new requirements. Nothing will be concurrent with your probation revocation case. You're to stay away from all Family Dollar stores. You're not to enter a single store that has the name Family Dollar on it. Do you understand?
Yes, ma'am.
You are to complete a new anti-theft class and to do an additional 40 hours of community service plus an additional $500 fine. This is in addition to your revocation case. For case ending in 1959H, this will be 12 months probation consecutive to 8118H. Stay away from all Chevron gas stations. You're not allowed to enter any gas station that has the name Chevron on it. And again, to stay away from all Family Dollar stores. With regards to case 24 CR 004142H, this will be 12 months probation concurrent to 811H. And again, to stay away from all Chevron gas station stores and all Family Dollar stores. Do you understand, sir? It's not a specific address or specific location,
All
any
right.
store.
Yes, ma'am.
At your age, with your criminal record history, you're working towards keeping away from most businesses. So it's entirely up to you. You report to probation every month. You're required to pay probation fees every month. And any violation of your probation will trigger a probation revocation immediately. No more allowances and excuses. If you fail to report even once, probation is authorized to request a probation warrant immediately.
Yes, ma'am.
I cannot be any clearer than this, Mr. Berry. You're free. Thank you.
All right, thank you, Judge.
We
Wait.
we have a Spanish interpreter case, Miss Vigiletti or Mr. McLean. Do you have a client requesting interpreter services?
Yes,
Uh,
that's, position number 3. He's in the courtroom right now.
Right,
Okay,
Mr. Celestino.
all right, so position 3. Isidoro, and you said he needs to be in a breakout?
He's in the courtroom currently.
Yes, Your Honor, we would need a breakout with the interpreter.
All right, Deputy, how do you arrange that with Mr. Celestino and our interpreter and Mr. McLean?
Right.
Can you place him in a different room?
Yes, Officer Norris is gonna take them back.
All right. Ms. Champion, as soon as Mr. Celestino is in a different location, and Mr. McLean, you probably have to be on a different device.
Yes, Your Honor, I'll sign on from the phone.
Okay, Miss Idaline, as soon
Sure.
as they are in a different location, you will be placed in a breakout with Mr. Isadora and Mr. McLean, okay?
Thank you very much.
All right, thank you. We sorry, just jumping back to position 21. And Mr. Tang, good morning, sir.
Good morning, Judge.
All right, sir. May I place you under oath, please? Do you raise your right hand? Do you solemnly swear and affirm that the interpretation services you provide for the Burmese language will be a true and accurate interpretation with no changes or embellishments?
Yes, I do.
Thank you.
You're welcome, Judge.
We are addressing Tandar Tue. Am I pronouncing her last name correctly?
တန်တာထွေးအမှုနဲ့ပတ်သက်ပြီးတော့မှကျွန်မတို့အခုဒီပြောပါမယ်တဲ့တန်တာထွေးနာမည်မှန်ပါတယ်နော် Yes. Yes.
Her case number is 24 CR 3766F, and she's accused of theft by taking from April 26, 2024.
You know, Judge, may I jump in?
Yes.
The client can speak perfect English, so maybe Miss Olivia can explain a little further about that.
Oh, well, I didn't know that. Ms. Vigiletti, do we have a change?
Yes, Miss Tway was flagged to me as a person who needs a Burmese interpreter. Her English is very good. She did ask for the translator to stay in case, because legal language is different from, conversational language. So she asked for the interpreter to stay in case she needs him, but we were able to speak without much trouble at all this morning. So
Understood.
if perhaps Miss Tway, you just let us know if you need anything translated, okay?
All right, Mr. Tang, if you would just please stay on alert in case she needs explanation of any particular words or phrases.
Yes, Your Honor.
Ms. Tway, you have a right to remain silent about the facts of the case of which you've been accused. Anything you decide to say about the facts or circumstances, your statements can and will be used against you in the prosecution of your case. Do you understand? You need to speak up.
Yeah, I understand.
Thank you. You have a right to an attorney. If you cannot afford one, you will be appointed counsel to represent you, and Ms. Vigiletti is your appointed counsel. You are presently accused in Fulton County State Court of a misdemeanor offense of theft by taking from April 26, 2024. Anytime that you don't understand what I'm saying, please raise your right hand so I will stop to let the interpreter translate. Do you understand? Presently, Ms. Vigiletti, how are we proceeding in her case?
Your Honor, Mrs. Tway would like to enter a not guilty plea this morning, and I do have a bond request.
Okay, and will you be filing a waiver of arraignment or shall I arraign the case?
I'm happy to file a waiver, Your Honor.
All right. Ms. Tway, your attorney, Ms. Vigiletti, will be filing a document where she will be entering a not guilty plea on your behalf, and your case is going to be further notice or further scheduled for a trial. Do you understand? Can't hear you.
I heard of signature bond. Does it apply today?
You do not have a signature bond. You have $1,000 surety bond. You have a bond where you would have to pay $1,000 to be released, or you would have to go through a bonding company and pay a percentage between 10 to 15% to be released. That is your current bond.
I haven't made the argument yet, Ms. Tway.
No. Ms. Tway, do you understand what's going on so far?
She had told me signature bond
Okay.
releases of
May I
payment.
jump in, Judge?
Yes, please do. And translate
Okay.
translate this information.
ဟုတ်ကဲ့တရားသူကြီးပြောတာက yes or no ပဲမေးတာပါကျန်တဲ့ဟာမဖြေပါနဲ့အပူမမေးတာမဖြေပါနဲ့ Miss Olivia ပြောတာပါညာအကုန်ခဏအသာထားအောင်သူမေးတရားသူကြီးပြောတာကဒီအခုသူက bond ခုနက self signature ဝေးပါညာပေါ့အဲ့ဒါကိုခဏထားလိုက်အောင်အဲ့ဒါခဏခောက်ထားလိုက်ဒီနေ့ထွက်ချင်1000ပေးရမယ်မထွက်တန်ဘူးပတ်စံမရှိဘူးဆိုရင်တော့သူက bond company ကိုခေါ်ပြီးတော့10 to 15% ကိုပေးပြီးတော့မှပဲထွက်လို့ရမယ်ဒါကတရားသူကြီးပြောတာသူမေးတာကတော့တိတလားသူပြောတဲ့ဟာနားလေတလားနားမလဲဘူးအဲ့ဒါပဲသူခဏမေးတယ်ပြီးမှဒီက Miss Olivia ဒီအမရဲ့ရှေ့နေကပြောပေးမပြောစရာရှိတာအများကြီးမဖြေမိပါစေနဲ့ပေါ့နော်အဲ့တော့တရားသူကြီးမေးတာ you understand သဘောပေါက်တယ်ပဲပြောပေးကျန်တဲ့ဟာကိုဒီကရှေ့နေကပဲဆက်လက်ပြီးတော့တောင်းဆိုပေးမယ်ဟုတ်ပြီလား
Ms. Tway, do you understand now?
Well, she had,
Yes, you are correct. You are correct. Your attorney is going to argue for a signature bond. She's going to ask the court to change it from a surety bond to a signature bond. But she hasn't done that yet. Do you understand?
yes,
But right now, she's indicated that you want to plead not guilty and your case will go to trial.
yes.
Okay, so now I'm going to let her argue for a signature bond. If you don't understand her arguments, please raise your hand. Do you understand?
I thought if you have signature bond, it
Hang on. Please translate, Mr. Tang.
သူပြောတာမဖြေနဲ့အောင်ဖြေခြင်းစိတ်ကိုမရှိနဲ့အောင်မဖြေနဲ့အောင်သူမေးတာကတရားသူကြီးပြောတာကအခုနသူ bond ကိစ္စကိုသူရှင်းပြတယ်သူရှင်းပြတာကိုနားလေသလားလို့သူကမေးတယ် okay ပြီးတော့ဒီဘက်ကရှေ့နေကနေ Miss Olivia ကနေသူက bond နဲ့ပတ်သက်ပြီးတော့မှသူက argument သူလုပ်မယ်အဲ့ဒါမှသူကတောင်းဆိုမယ်ရှေ့နေသူတဆင့်ချင်းလာတာအစစ်မကြော်နဲ့တရားသူကြီးမေးတာပဲဖြေဟုတ်ကဲ့နားမလဲဘူးပြီးမှရှေ့နေရပဲသူလောက်ကြရှိတာကိုတရားသူကြီးတင်ပြမယ်တရားသူကြီး court ကနေပြန်ပြီးတော့မှသူတို့ဆုံးဖြတ်ချက်ချမယ်ဒီ self signature bond ကို approve လုပ်မလုပ်ဆိုတဲ့ကိစ္စကိုသူတို့ပြန်စဉ်းစားမယ်အဲ့လိုတစ်ဆင့်ပြီးတစ်ဆင့်တက်လာမယ်ရှေ့နေပြောတဲ့ဟာအဲ့လိုငါကျမပြောထားတာရှေ့နေပြောတာတရားသူကြီးကသူကဆုံးဖြတ်ချမယ်တရားသူကြီးအဲ့သူမေးတာပဲဖြေပေးပါတတ်နိုင်ဆုံးပေါ့နော်အစစ်မကြော်ပါနဲ့နော်ဟုတ်ပြီနော်
I thought the signature bond, if approved, releases the trial.
No.
No.
Okay, so Miss Vigiletti, right now I've got your waiver arraignment. You are free to go into another breakout with her, or you can argue your bond right now. Mr. Tang, please translate.
ဟုတ်ကဲ့အဲ့တော့တရားသူကြီးပြောတာက Miss Olivia ပြောပြတယ်အခုဟုတ်ကဲ့ခင်ဗျား proof တော့ကျမတို့ဘာမှမလုပ်ရသေးဘူးတရားသူကြီးဘက်ကနေဟုတ်လားခင်ဗျားပြောတာလည်းမှန်တယ်ဒါပေမဲ့တရားသူကြီးကတရားရုံးကနေအဲ့ဒီဟာကို approve ပေးတဲ့ self bond signature ဝေးလို့မဟာလို့သူမပြောရသေးဘူးအဲ့တော့အခုပြောချင်တာကဒီရှေ့နေကိုတရားသူကြီးတင်ပြခိုင်းမယ်အစစ်မကြော်ပါဇက်ကိုခဏပိတ်လိုက်အစစ်မကြော်စေခြင်းဘူး
Okay. So, Miss Vigiletti, go ahead and make your argument and Mr. Tang will translate.
Okay, thank you, Judge. Okay, so I am requesting, Your Honor, a signature bond today. Ms. Tway is being held on a $1,000 surety bond. The plea offer from the state did not request any additional jail time. I'm sorry, are we translating the whole argument? Should I take pauses?
Yes, you should.
Okay, and so I'll stop there.
ဟုတ်ကဲ့အဲ့တော့တဲ့အခုတရားဒီရှိနေရပေါ့နော်ဒီကအရှိနေရတရားသူကြီးစီမှာဟုတ်ကဲ့ကျမတို့ဒီနေ့တောင်းဆိုချင်တာကတော့ပေါ့နော်ဒီ self bond ပေါ့နော် self bond အတွက်ကိုပဲဒီ signature bond ကိုယ်တိုင် self signature bond အတွက်ပဲကျမတောင်းဆိုချင်ပါတယ်အကြီးကပါလဲဆိုလို့ရှိရင်ဒီအမှုနဲ့ပတ်သက်ပြီးတော့မှာပေါ့နော်သူကဒီပြောရမှာဆိုရှင်ဒီဆက်လက်ပြီးအမှုခံကြဆက်လက်အမှုကိုစစ်ဆေးခံခြင်းလို့လည်းဖြစ်ပါတယ်ဆိုပြီးတော့မှတရားသူကြီးကဒီရှိနေမှာကတောင်းဆိုထားပါတယ်အခု
And Your Honor, our primary reason for requesting a signature bond today really is because the facts of the case just don't indicate that this is a theft.
အဓိကအဲ့လိုမျိုးဟာလာကိုယ်တိုင်လက်မှတ်ထိုးပြီးထွက်လာဖို့အတွက်တောင်းဆိုချင်တဲ့အကြောင်းရင်းကတော့ပြောမှဆိုအပြစ်မရှိဘူးပြောချင်တယ်ပြီးလို့ရှိရင် theft ခိုးမှုအရာမရောက်ဘူးလို့ကျမတို့ကထင်လို့အခုလိုမျိုးတောင်းဆိုရခြင်းဖြစ်ပါတယ်တဲ့
Ms. Tway's story does line up with the police report. She does explain that she picked up a laptop that was left on a library counter. She didn't know if it was a library device or not. She opened it up at a different table, realized that it was password protected, closed it, and left it on that table.
အဲ့တော့ Miss Tway က Miss Tway ရဲ့ပြောပြချက်အရာရဲစင်မှာ report ပြောပြချက်အရာကတူညီမှုရှိပါတယ်တဲ့သူပြောခဲ့တော့ကလည်းရဲစင်မှာ report ပေးခဲ့တော့ကအရာနဲ့ဒီနေ့ကျမမေးတဲ့အရာနဲ့အတူတူပဲပြောချင်တာပါလဲဆိုတော့ Miss Tway ကိုသူတို့ကရေးရမေးတယ်သူရဲစင်မှာသူပြောပြခဲ့တယ်ဒီ laptop က library ဥစ္စာလားသူများဥစ္စာလားသူမတိခဲ့ဘူး Miss Tway မတိခဲ့ဘူးအဲ့တော့ယူသုံးလိုက်တယ်ဖွင့်တဲ့အခါကျ passcode လို့တဲ့အခါကျ passcode ကိုသူကမတိဘူးအဲ့တော့သူကအဲ့ဒါပြန်ပိတ်ပြီးအဲ့မှာပြန်ထားခဲ့တယ်အဲ့စပွဲထဲမှာပဲစပွဲပေါ်ပြန်တင်ပြီးထားခဲ့ပါတယ်ဆိုပြီးတော့မှပြောပြခဲ့ပါတယ်
And her story is plausible, and she does want the opportunity to prove her case against her.
အဲ့တော့ဘာဖြစ်လို့ဒီအမှုမှာပေါ့နော်ဒီအခု Miss Tway ကသူဟာပေါ့နော်တက်တည်ပြခြင်းမှာသူအမားမရှိသူအမားမလုပ်ပါဘူးသူမခိုးပါဘူးဆိုတော့တက်တည်ပြခြင်းလို့အခုလိုမျိုးတောင်းရခြင်းဖြစ်ပါတယ်ပေါ့နော်
I don't think we're going to have any problem with her coming to court. She's provided me a stable address where she lives with family. She's also provided me a phone number.
အဲ့တော့သူဟာနောက်တစ်ခါဒီတရားရုံးပြန်လာဖို့အတွက်အမှုဒီမှာရင်ဆိုင်ဖို့အတွက်ကတော့ကျမစိုးရင်စရာမရှိပါဘူး။ဘာဖြစ်လို့ဆိုသူကကျမရဲ့သူ့ရဲ့အိမ်လိပ်စာလည်းပေးထားတယ်ဖုန်းနံပါတ်တွေလည်းပေးထားတယ်ဆိုတော့သူဟာတရားရုံးနောက်တစ်ချိန်ပြန်လာမယ်လို့ကျမကယုံကြည်ပါတယ်
And I'm sure she would be happy to comply with any terms of bond. For example, staying away from Georgia State and staying away from the complaining witness.
အဲ့တော့ကျမကပြောတောင်းဆိုချင်တာတရားသူကြီးစင်မှာတဲ့အခု Miss Tway ကိုပေါ့နော် Georgia State လို့ဖြစ်ဟာလာပြီးလို့ရှိရင်အဲ့ဒီအိမ်ပိုင်ဒီ laptop ပိုင်ရှင်နဲ့ဖြစ်အဲ့နားတဝဲလောက်မှာမနေဖို့အတွက်ဒီအမှုစစ်ဆေးအတော်အတွင်းမှာအဲ့ဒီကျောင်းနေအဲ့လူနဲ့အဲ့ laptop ပိုင်ရှင်နားမှာသွားမနေဖို့အတွက်ကိုကျမတို့အာမခံနိုင်ပါတယ်တဲ့
While Ms. Tway has only lived in Georgia for about 7 months, she's not new to the US. She was living in Virginia before, and like I said, she does live here with a relative, so she does have some support.
ဟုတ်ကဲ့ခုန Miss Tway ဟာ Georgia ရောက်တာ9လလောက်ပဲရှိပါသေးတယ်ဒါပေမဲ့သူမက Virginia လာတာဖြစ်ပါတယ် US ရောက်တာတော့ကြာပြီပေါ့နော်ဘာပဲပြောအခုပြောတယ်လို့မျိုး Georgia မှာကျသူ့မှာအမျိုးတွေရှိတယ်အဲ့တော့သူ့မှာသူ့ကို support ထောက်ခံမဲ့သူတွေရှိပါတယ်ဆိုပြီးတင်ပြပေးတဲ့တရားသူကြီးစစ်မှာ
Your Honor, I don't believe anything is gained by her being in custody while we have an opportunity to sort this out. So that is why we're requesting a signature bond this morning.
ဟုတ်ကဲ့အဲ့တော့အခုကျွန်မပြောချင်တာကတော့ဒီဟာအားလုံးကျွန်မတို့ဒီအမှုကိုတက်တည်ပြရင်ဆိုင်နိုင်ဖို့အတွက်သူမဒီ Miss Tway ကိုထောင်ထဲမှာမနေစေချင်ဘူးထောင်ထဲကနေထွက်ပြီးတော့အပြင်ကနေပဲအခုလိုမျိုးသူတို့ကအမှုကိုဆက်လက်လာပြီးတော့ရင်ဆိုင်ဖို့အတွက်နဲ့တက်တည်တွေသူတို့ရှာနေတဲ့အချိန်မှာပေါ့လေဆိုပြီးတင်ပြပေးပါတယ်တရားသူကြီးစစ်မှာ
I'm sorry, you said she's from Virginia?
She lived in Virginia prior to living in Georgia.
And does she have a prior address in Virginia?
I didn't ask her for one, Your Honor.
And you said she has a address in Atlanta?
Yes, Your Honor, and I do have that.
And have we contacted her family?
For cultural reasons, she does not want me to.
Okay. Anything else, Ms. Vigiletti?
No, Your Honor.
Okay. Ms. Bostic, do you have any, I'm sorry, Mr. Tang, please translate. If you need me to repeat anything, let me know.
Okay. အဲ့တော့အခုသူကမေးတာပေါ့ဒါဆိုလို့ရှင်တရားသူကျဒါဆို Miss ဘောနော် Miss Olivia ဘောနော်ဒါဆိုရင် तू က Virginia မဟုတ်ပါ तू Virginia မှာ तू နေထိုင်ခဲ့ပါတယ်ဒါဆိုရင်ဒီမှာရှိတဲ့အမျိုးတွေဖုန်းနံပါတ်အမျိုးတွေဆက်သွယ်လို့အမျိုးတွေဆက်သွယ်လို့ तू ကမဆက်သွယ်ခိုင်းပါဘူးတဲ့ तू အမျိုးတွေမသိစေချင်ဘူးပေါ့နော်တဲ့အဲ့တော့ပြောချင်တာကတရားသူကြီးကနေအားလုံးတေချာတော့ပြန်မေးချင်တာပေါ့သိအောင်
All right. Miss Bostic, does Miss Tway, position 21, have a pretrial record?
Judge, in regards to the defendant, she's a multi-state offender.
Thank you. Miss Mokeke, anything to add?
Yes, Your Honor. This defendant was already given a criminal trespass warning from classroom south of Georgia State University, and that classroom connects to the library.
Please pause.
အဲ့တော့သူတို့ကမေးတယ်အဲ့တရားသူကြီးကဒီ state ဘက်ကိုမေးတယ်ဒီ Miss Tway ရဲ့ရာဇဝတ်မှာဘာရှိခဲ့ဘူးလဲဆိုတော့အရင်တော့ကလည်း तू ကပေါ့နော်ဒီအစိုးရနဲ့ပြဿနာသူတို့တွေအမှုရင်ဆိုင်ခဲ့အရင်တော့ရှိခဲ့ဘူးတဲ့ပြီးတော့ဒီကဆရာမဒီက Miss Moke ဆိုတဲ့ဆရာမကလည်းဗာပြောလဲဆိုလို့ရှိရင် Georgia State မှာတော့အရင်တော့ trespassing အမှုနဲ့လည်း तू အရင်တော့ရင်ဆိုင်ခဲ့ဘူးပြီးတယ်ဆိုတဲ့အကြောင်းကို तू တင်ပြတာပေါ့သူတို့ပြောပြတာအရင်တော့အမှုရှိခဲ့ဘူးတယ်ဆိုတော့ तू ပြောပြတာပေါ့နော်
The defendant is seen on video with the laptop in her possession, and she did not turn it in to any library officials or any other school officials if she happened to find it and just thought it was lost.
အဲ့တော့သူပြောချင်တရားကရှိနေဒီအစိုးရဘက်ကလူကဗာပြောလဲဆိုတော့သူတို့တွေကကင်မရာချောင်းကနေသူတို့ကင်မရာကြည့်တဲ့ခါကျတော့အဲ့ဒီထဲမှာသူတို့ laptop ကိုသူကယူလိုက်တယ်ဒီလူကပေါ့နော်ဒီတရားခံယူပြီးတော့ဘယ်သူမှသူမအပ်ခဲ့ဘူးဆိုတဲ့အကြောင်းပြန်ပြီးပြောပြတာပါ
And then she continued to stay in the library even after the library was closed. And as pretrial said, she is a multi-state offender.
အဲ့တော့သူမဟာဒီ library close လောက်ပြီးတဲ့တောင်မှသူဆက်လက်ပြီးအထဲမှာနေတော့ပဲတဲ့ပြီးလို့ရှိရင်ခုနပြောတဲ့လိုမျိုး तू ကတခြား state မှာလည်းအဲ့လိုမျိုးအရင်တုန်းကလည်းပေါ့နော်ဒီအမှုချင်းဆိုင်ခဲ့ဘူးတယ်ပေါ့
It looks like she has larceny arrest from Virginia. She has a 2024 theft by taking, financial card transaction fraud, and manufacture, sale, distribution of identification documents from Georgia.
အဲ့တော့ပြောဆိုရင်ဒီ Virginia ကနေအမှုတွေအများကြီးဆိုင်ခဲ့ပူပြီးတယ်ပြီးလို့ရှိရင်ခိုးမှုတွေလူပေါ့နော်ခိုးမှုကတ်ခိုးမှုတွေပြီးလို့ရှိရင်သူများငွေကြေးနဲ့ပတ်သက်ပြီးတော့ဟာတွေပြီးတော့သူများ ID နဲ့ခိုးမှုတွေအမျိုးစုံပဲသူမှအမှုပေါင်းမျိုးစုံရှိခဲ့ပူပြီးသွားပါပြီဆိုပြီးသူတို့ကတွေးလိုက်တာကိုသူတို့ပြန်ပြီးတင်ပြတရားသူပြန်ပြီးတင်ပြတာပါ
And it also looks like she has a breaking and entering, larceny, possession of stolen goods, and break or enter a motor vehicle out of North Carolina.
နော် Carolina မှာလည်းကားတွေကိုပေါ့နော်ဝင်ပြီးတော့မှအဲ့လိုမျိုးကားတွေကိုလည်းသူဒီလူခိုးမှုတွေလုပ်ခဲ့ပူပါတယ်ဆိုပြီးထပ်ပြီးတင်ပြပေးလိုက်ပါတယ်
So based on her history, we believe that the bond should remain as is.
အဲ့တော့ကျမတို့ဒီရှေ့နေပေါ့နော်ရဲအစိုးရဘက်ကနေကြည့်မယ်ဆိုရင်ဒီ bond ကတော့ဒီတိုင်းရှိစေချင်တယ်အခုနကအာမခံကြေးကတော့သူတို့မလျှော့ချင်ဘူးတဲ့
Miss Vigilante, anything else to add?
Just one question. Ms. Okeke, are you referring, when you talk about the prior case in Georgia, are we referring to the dismissed case or is there something else?
That case is dismissed, so we can move on.
Okay.
Yeah, Mr. Thang?
အဲ့ဒါဆိုရှင် Miss Olivia ပါပြောစရာရှိတာပြောစရာတော့မရှိဘူးတခုလေးကတော့အရင်တော့ခုန Georgia မှာအမှုရှိခဲ့တယ်ဆိုတော့ကျတော့အဲ့တော့အဲ့ဒီအမှုတော့ dismiss ပြီးသွားပြီပေါ့တော့အဲ့ဒါပြဿနာမရှိဘူးအဲ့ဒါထားလိုက်တော့တဲ့
And I want to be very clear, the felony case was dismissed. We still have this misdemeanor theft by taking, that's still an open case.
ဟုတ်ကဲ့အဲ့တော့ခင်ဗျားကိုသိချင်တာကတော့အခုဒီ felony အမှုနဲ့ပတ်သက်ပြီးတော့မှာတော့အဲ့ဒီအမှုကပြီးသွားပြီဒါပေမဲ့အခုဒီဟာကတော့ဗာလဲဆိုတော့ကိုယ်ကိုတာစီကမရှိဘဲနဲ့နော်စီကမရှိ misdemeanor အနေနဲ့ပဲဒီအမှုကိုသူတို့ဖွင့်ခြင်းဖြစ်ပါတယ်တဲ့တေချာပြန်ပြီးရှင်းပြတာဒီအမှုနဲ့ပတ်သက်ပြီးတော့ misdemeanor ဆိုပြီးတော့ဗောနော်
Miss Vigilante, anything else to add?
Your Honor, I will just, I'm sorry.
Okay.
I have,
မပြောနဲ့
Your Honor, I will just, draw your attention to the police report, which, doesn't say anything about her having a laptop on her person when the police did find her in the library. So although it may have been a better idea to turn it in, you know, not turning a lost laptop in doesn't constitute theft. And so that's why we need an opportunity to get more information here.
အဲ့တော့ Miss Olivia ပြောချင်တာကဟုတ်ကဲ့ရဲတွေကလည်းရောက်တဲ့အချိန်မှာ ဒီ Miss ထွေးခန္ဓာကိုယ်မှာ laptop ကမရှိဘူးအဲ့ဒါကြောင့်ပြောချင်တာကဒီ laptop သူတကယ်မခိုးခဲ့ပါဘူးပေါ့နော်။ तू ကတကယ်ပဲယူလိုက်တယ်ဒါပေမဲ့ तू ပြန်ထားခဲ့ပါတယ်ဆိုတဲ့အကြောင်းရဲရောက်တဲ့အချိန်မှာ Miss ထွေးရဲ့ခန္ဓာကိုယ်ထဲမှာ laptop မရှိခဲ့ဘူးအဲ့ကြောင့်ဒီအမှုမှာခိုးမှုမရောက်ဘူးအနေနဲ့ဒီပေါ့နော် Miss ထွေးကိုပေါ့နော်ဒီပေါ့နော် bond ပေါ့နော်ဒီအာမခံကိုပတ်စံပေးစရာမလိုဘဲနဲ့အပြင်မှာထုတ်ပေးလို့ရမလားဆိုပြီးတင်ပြပေးပါတယ်တရားသူကြီးစင်မှာ
All right, thank you. With regards to whether the laptop was in her hand or not in her hand, that is an issue to be fleshed out during trial. Ms. Tway is legally presumed innocent of the charge, and the case will go to trial where the state would have to prove the charge against her beyond a reasonable doubt.
Okay, အဲ့တော့ Miss ထွေးခန္ဓာကိုယ်ထဲမှာ laptop ကိုတွေ့မတွေ့ကျွန်မအဲ့ဒါတွေကစိတ်မဝင်စားဘူးအဲ့တော့သူမဟာဒီထောင်ထဲမှာဆက်နေရမယ်အမှုကိုဆက်လက်ပြီးစစ်ဆေးဖို့လာရမယ်အဲ့ဒီအမှုကြလို့ရှိရင်ရဲတွေကလည်းတက်သေးတယ်အကုန်လုံးနဲ့ခိုးမခိုးကိစ္စကိုအမှုတစ်ခါပြန်ပြီးတော့ trial ပြန်လုပ်ဖို့လာဖို့လိုပါလိမ့်မယ်တဲ့
The record presently shows that she is residentially challenged. Her last known address was Baltimore, which has not been divulged by her, but that's the information on her booking screen.
အဲ့တော့သူ့ရဲ့ booking screen ကျွန်မကြည့်တဲ့ခါကျတော့ရှင်နောက်ဆုံးသူ့ရဲ့လိပ်စာကအထည်တကျမရှိဘူး Baltimore မှာဖြစ်နေတယ်အဲ့တော့သူအဲ့ဒါကြည့်ချင်းအဖြစ်နဲ့သူဒီတရားသူကြီးကသူအဲ့လိုမျိုးထုတ်ခွင့်မပေးချင်ဘူးပေါ့
As far as I know, that's in the state of Maryland, not Virginia.
အဲ့တော့ Baltimore ဆိုတာက Virginia မဟုတ်ပါဘူး Maryland ဖြစ်ပါတယ်
And furthermore, it's troubling that Ms. Tway is a multi-state offender with no ties in the state of Georgia.
ဟုတ်ကဲ့အဲ့တော့ Miss ထွေးကပြောမယ်ဆိုရင် state တိုင်းမှာပြဿနာဖြစ်ခဲ့တယ် state တိုင်းကနေရင်ဆိုင်ရတဲ့အမှုတွေရင်ဆိုင်ရလို့ဖြစ်တဲ့ကြောင့် Georgia မှာဆိုလို့ရှိရင်လည်းဒီလိုဖြစ်မှာပဲပေါ့
Any alleged ties to the state of Georgia, given her current circumstances, are highly questionable.
အဲ့တော့ဘာပဲပြောဒီဟာနဲ့ပတ်သက်ပြီးတော့မှ Georgia အနေနဲ့ဆိုလို့ရှိရင်ကျမတို့ကပေါ့နော်အရန်ကိုသူ့တတိထားမယ်အနေထားဖြစ်နေ Georgia state အနေနဲ့ကျမသူ့တတိထားမယ်သူဖြစ်ပါတယ်တဲ့သူမဟာ
The request for a signature bond is denied. Her bond remains at $1,000 surety bond to stay away from all Georgia State University property.
အဲ့ဒါကြောင့်ခင်ဗျားတို့ရဲ့တောင်းဆိုတဲ့ဒီပေါ့နော်ဒီကိုတိုင်းဒီ bond ပတ်စံပေးစရာမလို့ထွက်ချင်တယ်ဆိုတဲ့အမှုကျမကပယ်ချပါတယ်သူထွက်ချင်တယ်ဆိုရင်$1,000အာမခံ bond ပေးကိုပေးရမယ်တဲ့ Georgia University နဲ့တဲမှာလည်းတွားပြီးမနေရဘူးတဲ့ဟုတ်ပြီနော်
Her case will be further notice for trial.
အဲ့တော့
One moment.
trial အတွက်ကိုသူကရက်ဆွဲပြန်ပေးမယ်ဒါပါပဲ
Ms. Tway, you have a right to remain silent. If you decide to say anything else about your case, it will be very difficult for your attorney to defend you.
Miss ထွေးစကားပြောစရာမလိုဘူးခင်ဗျာပါဇက်ကိုပိတ်ပြီးနေလို့လည်းရတယ်အကေးမပိတ်ဘူးဆိုလို့ရှိရင်ခင်ဗျာပြောတဲ့ဟာမားလို့ရှိရင်ခင်ဗျာကိုပြန်ပြော against ပြန်လုပ်လို့ရတယ်နော်တဲ့အဲ့ဒီခါကျရှင်ခင်ဗျာရဲ့ရှေ့နေအတွက်ကတော်တော်လေးကိုဖြည့်ရှင်းရဖို့ခက်သွားလိမ့်မယ်ကိုပါဇက်ပြောတဲ့ခါကျအမားပါမှာဆိုလို့ငငင်လေးပဲနေပြီးနေလို့လည်းရတယ်ပေါ့နော်တဲ့
I already have served 2 weeks or so when is my due date out?
You have not served 2 weeks. You are in jail because you did not make bond. You're not serving a sentence. You're in jail because you have a surety bond. You would have to pay for your bond to be released.
အဲ့တော့ပြောတရားသူကြီးပြောတာကခင်ဗျားဟာထောင်ထဲမှာနေတာ jail မှာပဲနေတာပါ sentencing မလုပ်ရသေးပါဘူးခင်ဗျားအမှုကိုစစ်ဆေးကိုမလုပ်ရသေးတာ
You're
အဲ့တော့
sorry.
ခင်ဗျားဟာ2 weeks ဆိုပေမဲ့အဲ့2 round မဟုတ်ဘူးအဲ့တော့ jail ထဲမှာပဲနေရသေးတယ်အမှုကိုမစစ်ဆေးရသေးဘူးအဲ့ကြောင့် bond အာမခံလွတ်ချင်အာမခံပတ်စံ$1,000ပေးကိုပေးရမယ်
Your attorney will speak with you with regards to how you proceed from this moment forward.
အဲ့တော့ခင်ဗျားရဲ့ရှေ့နေကခင်ဗျားကိုအကြံပေးပါမယ်ဒီအမှုနဲ့ပတ်သက်ပြီးတော့မှဘယ်လိုလုပ်ရမလဲဆိုတဲ့ဟာကိုတဲ့နော်
Ms. Tway, just to make sure we're clear, we lost the bond argument today, but you weren't convicted of anything today. We're still fighting your case.
What if
Miss ထွေးမပြောနဲ့အောင်အဲ့တော့ခင်ဗျားကိုတဲ့ကျမတို့အခုတရားသူကြီးစင်မှာ bond ကိစ္စကိုပေါ့နော်ဒီပတ်စံဒီ signature နဲ့ bond ကိစ္စကိုတောင်းတဲ့ဟာကိုတရားသူကြီးကပယ်ချပါတယ်မခွင့်ပြုဘူးတဲ့အဲ့ဒီဒါပေမဲ့ခင်ဗျားအမှုကိုဆက်လက်ပြီးတော့မှ fighting လုပ်အောင်ပဲကျမတို့ကတဲ့ဟုတ်ပြီလား
Right, Deputy Milton, we are concluded with this case. Ms. Vigiletti, she will come and speak with you.
What, I have
အဲ့
something
တော့ပြီး
else.
ဒီအမှုပြီးသွားပြီ Miss Olivia ခင်ဗျားကိုပြန်ပြီးလာပြီးတော့မှစကားပြောပါမယ်တဲ့ပြောစရာမရှိတော့ဘူးเนาะ
Okay, come on.
I'm not finished.
Come. Have a seat over there.
Ms. Vigiletti, please address your client's questions because
I certainly will.
I don't want her to incriminate herself.
Yes, I will.
Mr. Tang, thank you so much. I appreciate your time. Thank
Very
you.
welcome, Judge. See you next time. Bye bye.
Yes, sir. Bye-bye.
Bye bye.
Okay, Deputy in courtroom 2, where should I go to next?
You can go to a jail court's iPhone.
Thank you. The individual who's walking around with a Samsung phone, are you an officer? All right, Miss Champion, can you stop that video? Thank you. All right, jail court iPhone. Who do we have, please? Jail court iPhone. Good morning, officer. Who do we have this morning?
Sorry. Yes, this is position number 12, but it's a conflict.
All right, thank you, sir. This is Isaiah Grimes, charged with battery family violence from July 1st, 2023, under case 24 CR 1782E. Mr. Grimes, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is conflict counsel. Who is your attorney?
I'm sorry, Your Honor, we don't have a conflict as of yet for today. Ms. McLeod is in Judge Richardson, and she says she's going to try to log in once she's done.
All right. Mr. Ham, have you been in communication with Ms. McLeod?
I have not, Your Honor.
Okay. Mr. Grimes, your case is going to be reset to next Tuesday, July 2nd, 2024 at 9 a.m. for your attorney to reach out and speak with you with regards to any information that she may receive from the prosecution, and then she'll be able to report as to how she's going to move forward with your case.
Yes.
Deputy, his case is reset to July 2nd for Ms. McLeod to speak with her client.
Okay.
And Judge, FYI, he's already in custody on no bond on a felony case.
All right, thank you.
Your Honor, I have Mr. Grisby here. He's also a conflict. I'm trying to see which position he is.
Did you say Grigsby?
Yes,
Is he an add-on?
he's on the competency calendar,
Okay, just one second.
but it's a conflict case. So I'm not sure if they have the conflict attorney for today on any calendar.
I normally wait till 11 a.m. for conflict to show, but that's the time for the calendar. So you said he's on the 11 a.m. calendar?
Yes,
Okay, one second. Is Mr. Paul Bartel by any chance here? Okay,
He is, Your Honor. He's in the courtroom with us.
okay. Mr. Bartel, do you have any information with regards to Mr. Grigsby? Just give me a moment.
Good morning, Your Honor. I don't have any information right now. I believe they were waiting on a report back, if I recall correctly.
Okay,
Yeah, honestly, I haven't followed it because it's Ms. McLeod's case.
that's perfectly fine. Thank you very much.
You're welcome.
Mr. Grigsby, this is Derek Grigsby. Can you hear me, sir?
I can.
All right, sir, please remember that you have a right to remain silent about the facts of your case. Anything you choose to say, your statements can and will be used against you. Your attorney is Maureen McLeod.
Can you spell that?
Maureen, M-A-U-R-E-E-N. And McLeod is M-C-L-E-O-D. Your calendar is at 11 a.m. today. It is presently 10:22 a.m. I am going to wait till 11 a.m. to see if your attorney appears. and if she requires your presence, you will be summoned again. Presently, your case is going to be reset.
I'm John Powers, my attorney.
Presently, your attorney is not present right now. I'm going to wait till 11 a.m. for her to appear.
Okay. Can I look at
Your cases are going to be reset till July 11th, pending a report from your attorney at 11 a.m. today.
Can I, is there any way to get the case number
I
from
can
you?
get you those.
Your case numbers are 23 CR 004406G and
Wait, 23.
and let me repeat that case number, 23 CR 004406G. And then your second case is 24 CR 001591G.
CR 001591G
Correct.
and 44 and CR 004406G.
That would be correct.
And what courtroom are you in?
I'm on Zoom court.
No, your seated courtroom.
I'm in Zoom court at the present time. Thank you.
What's your courtroom? So I can
This
see?
is the Fulton County State Court. This
And-
is this state all-purpose calendar. Thank you, Mr. Grigsby. We will see you perhaps at 11 a.m. or perhaps on July 11th. Thank you.
Position number 5, Mr. Chestnut.
This is State versus Lamar Chestnut, middle name Bonnell, accused of reckless driving, DUI driving under the influence of alcohol less safe, and failure to maintain lane or improper lane change from January 7th, 2018. Mr. Chestnut, your case is 19 CR 4086Y. You have a right to remain silent about the facts of your case. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning, this is position number 5, is going to be private counsel, who is attorney Anthony Van Johnson. Is counsel Anthony Van Johnson on the Zoom session? All right. Mr. Van Johnson is not present. Your case is going to be reset to July 2nd, 2024 at 9 a.m. for your attorney to appear and address the court.
Excuse me, Judge. I don't have that attorney no more. Me and attorney, I fired the attorney. I need a public defender.
Okay, then Mr. McLean or Ms. Vigiletti will speak with you, and we will address your case on July 2nd after the Public Defender's Office have spoken to you and pre-qualified you for their services, and also to get information about your case.
Okay, thank you.
July 2nd, 2024, 9 a.m. Mr. McLean or Ms. Vigiletti, please make a note that Lamar Chestnut is requesting the services of the Public Defender's Office.
Absolutely, Your Honor.
We can go to the interpreter case.
Okay, and that was Mr. Isidoro,
Yes,
position 3.
Yes, Your Honor. His first name is Isidro. His last name is Celestino.
All right, and our interpreter, Miss Lee, Miss Adeline.
I think she needs to be brought into the main session.
No, she's here. We're just going
Okay,
to wait for her to unmute and start her video. Thank you, Ms. Lee. Ms. Lee, may I place you on the oath? Do you solemnly swear and affirm the testimony that you translate will be a true and accurate translation with no changes and embellishments?
I do.
Thank you. This is State versus Isidro Celestino in case 17 CR 17211A.
Este es el caso de Isidro Celestino 17 CR 017211A.
Mr. Celestino is accused of theft by receiving stolen property,
Al
driving.
señor Cele-
Go ahead.
Al señor Celestino se le acusa por aceptar artículos robados,
Driving without a valid license and acquiring a license plate for purposes of concealing a motor vehicle.
no manejar sin licencia y el obtener una placa para ocultar la identidad del vehículo.
The alleged incident date is from October 18, 2016.
Se alega que esto ocurrió el 18 de octubre del 2016.
Mr. Celestino had a court date on February 5th, 2018, where he did not appear.
El señor Celestino tenía que comparecer el 5 de febrero del 2018, pero él no compareció.
So a bench warrant was issued on March 1st, 2018.
Entonces se emitió una orden de arresto el 1 de marzo del 2018.
And he was detained on June 19th, 2024, and booked at the Fulton County Jail.
Y se le detuvo el 19 de junio del 2024 y se le fichó en la cárcel del condado de Fulton.
He currently has a cash bond for these charges in the amount of $3,810.
En este momento él tiene una fianza por estos cargos de $3,810.
As a result of his failure to report to court in 2018.
Por no comparecer al tribunal en el 2018, y es una fianza de dinero en efectivo.
Mr. Celestino has a right to remain silent. Anything he says about his facts, his statements can and will be used against him.
El señor Celestino tiene derecho a permanecer callado. Cualquier cosa que él diga puede usado y se usará en contra de él.
He has a right to an attorney. If he cannot afford one, Mr. McLean will represent him.
Tiene derecho a tener un abogado. Si él no puede contratar su propio abogado, el señor McLean lo representará.
Mr. McLean, how are we proceeding in your client's case?
Well, Your Honor, because this is my first interpreted session with him, although we did speak a bit yesterday, he has a little English. Because this is my first session with him, I would like to ask before we proceed that the state consider the logic of count 3 against count 1. Count 1 is theft by receiving of the plate, the license plate itself, whereas count 3 is acquiring a license plate for the purposes of concealing the identification of a motor vehicle. I would ask the court to, I would ask the state to consider that 3 would merge into 1 or vice versa, because it's not logical that a person receives and acquires both. The other point, Your Honor, would be.
Oh, just 1 second. Do you remember Mr. McLean? We have an interpreter who is very, very
I'm
good.
sorry. I'm sorry. Yes, I did forget
But
that.
I'll be impressed if you could translate that entire paragraph.
She can do it.
Solo antes de proceder, quisiera hablar y hacer la recomendación a la Fiscalía de que el cargo número 1 y número 3 deberían de juntarse, porque no es lógico que una persona sea acusada por recibir un artículo robado y también por obtener un artículo robado. Por lo tanto, pediría a la Fiscalía que se considere unir a estos dos cargos, el 1 y el 3.
Mr. Ham, would the state consider either merging or null crossing the acquiring license plate for purposes of concealment?
They have no objection, either a merger or null process on count 3.
Ok, entonces la jueza le preguntó al fiscal que si no tiene problema de no procesar o de unir los dos cargos, el 1 y el 3, entonces van a no procesar el cargo número 3, dijo el fiscal.
That's your response, Mr. McLean. What would your client like to do?
Your Honor, we would love to have the null process under the rule of lenity. I think that would be logical.
That's null, we're going to null cross count 3.
Ok, entonces la juez preguntó qué quiere a su abogado, qué le gustaría hacer al cliente, y el abogado está diciendo de que les gustaría de que no procesaran el cargo número 3. La juez aceptó que no van a procesar el cargo 3.
And Your Honor, the other matter before proceeding is that just in case there's any immigration problem, potentially, we did discuss such issues, and I'm going to ask the court to consider giving a sentence upon his guilty plea of less than 12 months, say 11 months.
Just one second, just one second. Interpret.
Okay. Yes, Your Honor. También queríamos abordar el tema de la inmigración, lo cual nosotros hablamos con el señor y hablamos sobre los asuntos de inmigración y voy a pedir que si cuando él se declare culpable, que en lugar de tener una condena de 12 meses, que sea menor de 12 meses para que así ayude con el problema de la situación migratoria del señor Isidoro.
Mr. Ham, any objection to a 11 months, 29 days sentence, the remainder subject to probation?
No objection, Your Honor.
¿Hay alguna objeción de que se acepte? Él está preguntando al fiscal si objeta o no quiere aceptar la solicitud del abogado de que la condena sea menor de 12 meses, que sea 11 meses y 29 días. La juez propuso esto y el fiscal acepta que sea una condena menor de 12 meses, que va a ser de 11 meses y 29 días con el tiempo que queda para cumplirlo bajo libertad vigilada.
All right, Mr. McLean, and what's your client's decision to move forward?
It is to move forward, Your Honor. We've been over all the questions on the plea sheet. I believe he is ready.
Okay.
Que si usted quiere proceder y su abogado dice que sí, que está listo para proceder y que hablamos de todas las preguntas que la juez le va a hacer a usted para presentar su declaración.
Mr. Celestino, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Señor Celestino, levante su mano derecha y usted afirma que el testimonio que va a presentar aquí va a ser la verdad ante las preguntas y ante este caso que tiene pendiente. ¿Lo jura, señor Celestino?
Sí.
Yes.
Thank you. Mr. Ham, what is the recommendation for counts 1 and 2?
Yes, Your
¿Cuál es la
Honor.
recomendación para el cargo 1 y 2?
Count 1, theft by receiving stolen property.
El cargo número 1, que es recibir propiedad robada.
State's recommendation is 11 months, serve 29 days.
11 meses y cumplir con 29 días.
Excuse me, let me correct that. It's 11 months, 29 days of probation.
Déjeme corregir eso, son 11 meses y 29 días de libertad supervisada.
Serve 22 days.
Le quedan 22, I'm sorry, 22 days, I didn't understand that.
Yes, serve 22 days, credit for the time served 11 days.
Got it, ok. Cumplir 22 días y se le reconoce los 11 días que ya cumplió, se le reconoce ese periodo de tiempo.
The balance to be served on probation in which he is to complete an anti-theft course.
El resto lo va a cumplir bajo libertad vigilada y también va a tomar una clase que llaman clase antirrobo.
The anti-theft course will terminate upon completion of all conditions and the payment of a fine.
Can you repeat that for me, please?
Sure. Anti-theft course will terminate upon completion of the conditions and payment of a fine.
La clase de antirrobo se acaba cuando complete la clase de antirrobo y pague las multas.
For count 2, driving without a valid license.
Por cargo número 2, manejar sin licencia.
State recommendation is 11 months and 29 days on probation.
11 meses y 29 días bajo libertad supervisada.
Run concurrent with count 1.
Que va a hacer al mismo tiempo que el cargo 1, va a ser lo mismo al mismo tiempo.
To pay a $210 fine.
Una multa de $210.
That completes it, Your Honor.
Y eso es todo.
Mr. McLean, does your client accept these terms and do you stipulate to the factual basis, venue, and ID?
Señor McLean, su cliente acepta esta oferta y usted estipula los cargos de fundamento que se hablaron.
He does, Your Honor, and for the purposes of the plea, we do so stipulate. Let me mention on my own, Your Honor, I believe under these circumstances, based on my discussion with him, and all candor to the court, I believe that his decision to plead guilty to the theft by receiving is essentially an offered plea because he says somebody said to him, drive this truck from point A to point B. He just didn't know the plate. He didn't know anything about that. He did.
Okay.
He did
Can
get out
you
of the
give me,
car.
Mr. McLean, can you allow me to interpret, please?
Yes.
Ok, si mi cliente quiere proceder y él quiere seguir adelante con esto, y bajo las circunstancias que hay, estoy pidiendo que en el cargo número 1, que fue por robo, por aceptar algo robado o un artículo robado, que él se pueda declarar bajo la declaración Alford, que es lo que más me conviene, debido a que a él le dijeron maneja este carro, lo llevó de un punto A a un punto B y él no sabía que la placa no pertenecía a ese carro.
The police report also says when he got out of the vehicle, he simply said in broken English that he did not have a license.
Y cuando la policía lo arrestó, que lo paró, él lo que dijo fue en un inglés mocho que él no tenía licencia.
Therefore, I would ask the court to consider that he's taking responsibility and to not hold it against him in any way on the nature of the overall transaction.
Y también le pido al juez que lo tome en consideración y que no lo tome en contra de él debido a cómo procedió todo esto que ocurrió.
Thank you.
Mr. McLean, so your client is agreeing that he drove a vehicle without a valid license.
Correct.
Señor
But-
McLean,
Go ahead.
su
Sorry,
cliente está de acuerdo en que él manejó un carro sin tener una licencia y el señor McLean dijo que sí, que yes.
But he does not believe that he knew that the license plate was improper on that vehicle.
Pero que él no pensaba, no sabía que la placa de ese carro no era la placa apropiada, no era la placa legal.
Correct, Your Honor, and he feels that he has substantial jury risk of losing that point at trial.
That's good. Go ahead.
Sí, y él también tiene cierto riesgo, el miedo al riesgo de perder eso, de perder este caso si fueran a juicio.
The plea is rejected. This is not going to be a bona fide acceptance of, I don't care whether he's doing the honorable thing or falling on the sword and deciding that he wants to plead guilty in order to get out of jail.
La declaración no se acepta, no estoy de acuerdo que lo esté haciendo de buena fe y de que él solamente quiere aceptar la oferta y declararse culpable para salir de la cárcel.
On the theft by receiving stolen property is a $500 good bond. On the driving without a valid license, it's a $500 good bond. His total bond is $1,000, is a surety bond. If he wants to have the case arraigned today, I'll be glad to further notice the case to trial, and the state can carry its burden to prove the charges against him.
No voy a aceptar la declaración, la multa, la fianza para el cargo de aceptación de artículos robados son de $500 y la fianza para el otro cargo de manejar sin licencia son $500, por un total de $1,000, que es una fianza por una compañía de fianzas. Si él quiere aceptar esto o si no, para que decidan si van a ir a juicio o no, que lo decida la fiscalía en el momento del juicio para probar estos cargos.
But he needs to understand that he has been in jail for 11 days because he did not show up to court in 2018.
Él tiene que entender que él estaba en la cárcel por 11 días porque él no se presentó a comparecer ante el juez en el 2018.
And if he doesn't show up in any future court appearances, we will have a repeat of this.
Pero si él no se presenta en cualquier otra comparecencia que haya ante el juez, vamos a tener que repetir esto.
Mr. McLean, would you like to file a waiver or shall I arraign the case?
Your Honor, let me explain that to him in a breakout so he understands what we've just gone through.
Understood.
Vamos a ir a una sala para explicarle lo que ocurrió, de que van a no tener la lectura de cargos y luego van a tener su cargo más adelante, su caso más adelante.
All right. Mr. McLean, you'll have to go into, well, is Miss Vigiletti available?
Yes, Your Honor, she's right here.
All right. Miss Vigiletti, can you get into a breakout?
Yes, absolutely. Who am I speaking with?
No, you're going to be speaking with us. We're going to put courtroom 2 in a breakout with Miss Lean.
Okay.
And you're going to address the case at Fulton, ACDC, and Jail Court iPhone.
Oh, understood, understood. Okay, yep.
Who do we have in Jail Court iPhone, by the way?
We have positions 37 and 38, Mr. Calvin Williams.
All right, is that your client, Miss Vigiletti?
No, Your Honor, but that is Ms. Hoda's client, and she is here and available as well. So we will both join you in a breakout.
Okay. Ms. Champion, please place courtroom 2 and Ms. Adaline in a breakout.
Your Honor, AC/DC screen is showing my client Ann Chapin.
Okay, but right now you need to just go over this little arraignment thing with Mr. Celestino, so I can further notice the case.
Very good. We'll go to the breakout room on that.
No, you stay in courtroom 2. Ms. Vigiletti, you get on or Ms. Hoda, you get on a device, and we will address jail court iPhone case. Ms. Adaline, you're going to go into a breakout with courtroom 2.
Thank
Ms.
you, Your Honor.
Champion, I hope I haven't confused
Your
you.
Honor, we still have other people here present. It would need to be a confidential session.
All right, then you get onto Ms. Vigiletti's device so that
Yeah,
we
Your
can
Honor,
in
it's
breakout.
also one deputy in the courtroom at the moment,
Yeah.
so
that's, I can reset the case to July 2nd if you want to have time to readdress this case.
You know, that probably would not be good if we could, as soon as the deputy comes back and we have 2, if I
you can,
could.
Your Honor, you can go ahead and put them in the
Protocol.
breakout room. I'm just gonna take the ones that's in here and place them back for a second.
That works as well.
Ms. Champion, please place courtroom 2 and Ms. Adaline in a breakout.
And Your Honor, AC/DC will turn the volume up and turn the picture off.
Okay. All right, position 37 and 38 is Mr. Kelvin Williams. Mr. Williams, I'm just waiting for your attorney, Ms. Atay, to appear, and then we will be addressing your cases.
Yes, ma'am.
Officer Goldie,
Yes,
when you're done there, can you meet me on 3 North?
okay.
All right.
All right, this is Kelvin Williams, case 24 CR 3430Y, accused of 2 counts of reckless conduct from September 4th, 2022. His second case is 24 CR 003-829Y, accused of battery, family violence, and cruelty in the 3rd degree from April 6, 2024. Mr. Williams, you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Hoda Atay, who is on the Zoom screen as well. Do you see her?
Yes, ma'am.
All right. Ms. Atay, I understand your client is entering a not guilty plea. Would that be correct? Please unmute Ms. Atay.
Yes, Your Honor.
Okay. Would you like me to arraign both cases, or will you be filing a waiver of arraignment?
I can file a waiver of, I can file a waiver of arraignment, but for position 37, I mean, I would claim that it's a Riverside issue. I mean, the incident date is September 4th, 2022. I have not seen a warrant on this. I don't think he's been served with a warrant. It was accused, I think, about a week or so before he was arrested. He's been in custody for 14 days.
He was booked in on the battery charge and a felony matter, and he was booked in on June 14th. The position 37, reckless conduct, appears to be a bind over. So there was never an issue of first appearance. So the only issue we are addressing is he doesn't have a bond holding him on the reckless conduct. There's no.
And so there's no bond. Okay, I didn't see that. Oh,
okay. So he has a bond on the aggravated assault, there appears to be the battery, family violence from May 29, 2024. That appears to be his Superior Court matters. And then the charges before us from April 6, 2024, he's got a $5,000 pretrial release bond.
okay. So, and the reckless conduct is not holding him.
No.
Okay, so so we'll just enter the not guilty plea today.
Okay. Please make a note that he does have a Superior Court matter that's holding him.
Yes.
All right. So Mr. Kelvin Williams, you're for the misdemeanor case of battery, family violence offense, cruelty to children, third degree. You have a $5,000 signature bond through pretrial release. So as soon as you take care of your Superior Court felony matter, you'll be released through pretrial services where you'll have to report. I can't remember whether it was once or twice a month. In the meantime, both cases in which your attorney is going to enter a not guilty plea, both cases are going to be further notice for trial. If you want, Miss Atay, I can do a $1,000 signature bond through the jail on each count of reckless conduct if you are more comfortable with that.
But so if the reckless conduct isn't holding him and it's a bind over, does that mean I don't know, usually bindovers come with a bond.
I don't see one that isn't even listed on his booking sheet. The case was just transferred. There's not
Okay.
even, it was just a case transferred to state court from municipal court, and then it was accused. At least that's what I see on that screen. There was no first appearance in state court. In other words, he was never booked into Fulton County Jail on that case. Now, if he was booked into some other jail, that would have been something else.
I think it may come up when he's going to be released. So I think the $1,000 signature bond through the jail is better.
Okay, so please submit a proposed order on a $1,000 signature bond through the jail. No weapons, no firearms, no illegal drugs. And the case is further notice for trial.
Okay, thank you, Your Honor.
Anything else, Ms. Atay?
Nothing further for Kelvin Williams.
All right. Mr. Williams, your attorney will speak with you with regards to the status of your misdemeanor cases, as well as your felony case. Thank you. But please make a note, you're not allowed to own a firearm, have a firearm on your person, or have a firearm anywhere near you. Not in your home, not in your car, not on your person. Thank you.
Yes, ma'am. Thank you.
Next case, please, with Ms. Atay or Ms. Vigiletti. No?
I think they'll probably have Ricky Williams, position 39, but I don't know where they
All right, let's see if Mr. Williams. Position 36 is released. Taniqua White. That's not your client, is it?
No, she's been released.
Okay.
I have also, I need to send a waiver for Latrice Shelton, a waiver of appearance. Officer Milton told me that she had court in downtown, so she wouldn't.
And this is Felton?
I'm
What
sorry?
Is that?
Position 28.
Okay. Position 28. And you're saying you need a reset? Latrice Shelton.
Yes, we can reset her until Tuesday.
Oh. Ms. Champion, how's our Tuesday calendar looking?
I'm sorry, no more for Tuesday.
I can reset it for, what's the Tuesday after, July 9th?
So she was fine with the plea offer, but other than, the fine, she can't pay the $500 fine. And she stated, so I could waive her appearance today and still represent her and ask for, well, I would really like to ask for a signature bond through pretrial services for her.
We'll need that waiver in writing.
Okay, so,
Your Honor, do you need a waiver of her presence to make a bond argument or just for a plea in her absence?
Yes, I do need the waiver because she's on the calendar.
Okay, they just told me this. So I'll send the waiver and then we can come back to her.
Perfect, thank you. All right, any other announcements, Ms. Attai, while we're waiting for either ACDC or jail court iPhone?
Your Honor, position 29 and 30, Shamika Smith has been released, so she will not be here today.
Thank you, Ms. Vigiletti. Okay, so
we-
position 29 and 30, further notice for trial.
Yes, and we also have a number of conflict cases, and so I'll just flag each of those very quickly. All of these people do have felony matters that are holding them in the jail.
Okay, which
So-
positions are those?
I believe we've already discussed position 12, Isaiah Grimes. That also applies to position 13, Zion Harper.
Okay,
Position 23, Troy Mathis.
okay,
Position 25, Jacob Patrick.
okay. 13, 23, and 25. Okay, I'll get back to those cases. Right now, I want to get back to Mr. McLean's case on Mr. Isadora. All right, Mr. McLean, please unmute. And Deputy, you can bring the folks back in. All right, resuming with Mr. Celestino. How are we proceeding, Mr. McLean?
Honor, I'm going to waive his arraignment and I'm going to ask the court to consider a signature bond.
Voy a renunciar a que se haga la lectura de cargo, voy a no ejercer ese derecho y voy a pedir que se le asigne una fianza bajo protesta o bajo palabra.
Grounds for a signature bond?
Your Honor, he has a stable address and stable employment, self-employment. Your Honor, I have an address that is in the local metro area that I can provide to the clerk. I have a phone number for him. He is solo in home renovation. So
Okay. El fundamento para que le den una fianza bajo palabra es porque su señoría, tengo aquí la información de una dirección que vive aquí en la zona de Metro Atlanta. También tengo un teléfono y él tiene un trabajo y trabaja por su cuenta en renovaciones. Por eso ese es el fundamento para que se le otorgue una fianza bajo palabra.
he tells me he gets good mail service at this address, which I have. In addition, Your Honor, I will explain to him about checking with the clerk in person.
También me dijo que recibe su correo en esta dirección que me dio y también le voy a decir para que chequee con la secretaria del tribunal en persona.
Ms. Bostic, do you have any GCIC on Mr. Celestino since 2018?
Yes, Judge, 2 arrests, both are for driving without a valid license.
Thank you.
Sí, tengo información sobre el señor Celestino de GCIC. Desde 2018 tiene 2 arrestos por manejar sin licencia.
Right. Bond on the theft by receiving is $500 and the driving without a valid license is $500. Total bonds of $1,000 surety. No driving at all.
La fianza para el caso de manejar, de aceptar este artículo robado es de $500 y la otra por manejar sin licencia son $500. $500 tiene que conseguir ese dinero y no puede manejar más. Esas son las condiciones de la fianza.
No driving unless he has a valid driver's license, adequate insurance, and proper registration.
No puede manejar a menos que tenga licencia válida, la matrícula válida y seguro válido.
Case is further notice for trial.
Y luego se le va a anunciar nuevamente cuándo va a ser la fecha para el juicio.
Thank you, Honor. The counts on
Gracias.
the 500 each was, I believe the court mentioned 2 counts there.
Theft by receiving and driving without a valid license, the acquiring license plate is null crossed.
Thank you, Honor. Okay.
Son 2 cargos, el otro cargo se lo retiraron, el cargo de manejar sin licencia de aceptar propiedad robada.
All right.
I will prepare that.
Ok, voy a preparar eso.
All right. Do we, Ms. Lean, could you please make an announcement if anybody else in courtroom 2 requires a interpreter, Spanish interpreter?
Yes, Your Honor. ¿Alguna persona, por favor, nos deje saber si necesita intérprete? Déjenos saber ahora para poder ayudarlo, asistirlo con esto.
No? Okay. Thank you, Ms. Lean. I appreciate your time. Thank you.
You're welcome. Thank you. Bye.
All right. Medical, who do we have, please? Medical unit, who do we have?
Williams, position number 39.
This is Miss Atay's client, Ricky Williams. Is Miss Atay back in? Yep, she is. Okay. This is case 24 CR 2909B. Mr. Ricky Williams has five misdemeanor offenses stemming from a May 6, 2024 incident at a MARTA facility. The charges are battery at a public transit vehicle or station, violation of certain rules regarding at a bus, rail, or station, 2 counts of criminal trespass, and a second count of battery at a public transit vehicle or station. Mr. Ricky Williams, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Hoda Atay. Ms. Atay, how are we proceeding in your case?
Yes, Your Honor. We would like to request that the offer as far as the probation and the no further contact, stay away from all MARTA, but I would like to request to remove the 60 hours of community service and the 8 weeks of anger management. He right now has a probation violation on another case where he could not pay about $140 in fees or complete the online course requirements. So he's been in custody for 51 days. He's been homeless for 8 years at least. He does not have a phone. He won't have a place to live when he gets out. So I think a requirement for community service and an 8-week anger management is really not possible for him.
All right. So I gather this will be a non-negotiated plea then.
Yes.
Okay. Miss Medical, please unmute. This is going to be a non-negotiated plea hearing. Mr. Williams, the prosecutor is going to make their recommendation, and then your attorney has presented her recommendation for a possible sentence if you decide to enter a plea. I will tell you which recommendation I will accept, and also will hear your criminal record history, at which point then you can decide whether you want to move forward and enter a guilty plea or whether you would like to have a trial. Please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Mokeke, what is the state's recommendation?
Yes, Your Honor. The state's recommendation for this case in which Mr. Williams is accused of assaulting 2 women on the MARTA station within 10 hours of each other is for count 1, 12 months probation served 120 days, credit for time served 51 days, balance probated, no further contact with the victims, Brandy Williams and Natalia Ramirez, stay away from all MARTA locations, 8 weeks anger management, 60 hours community service. For count 2, it is 12 months probation concurrent with count 1. For count 3, it is 12 months probation consecutive to count 1, stay away from all MARTA locations. For count 4, that is going to merge with count 3. And for count 5, it is 12 months probation concurrent with count 1. Mr. Williams does have 57 arrest cycles in Georgia, including numerous criminal trespasses, many of them from MARTA. He also has a looks like October 22nd, 2022, simple battery, where he again punched a woman in the face on the MARTA station.
All right. Ms. Atay, and you're asking me based on his criminal record history, based on a alleged repeat violation, and also your own statement that he's not a good candidate for probation, that his 8 weeks of anger management and his 60 hours of community service be removed. Would that be correct?
Well, not that he's not a good candidate for probation, but he just won't have a way. He doesn't have a phone. So yes, I would ask, I think it's setting him up for failure to ask him to complete 60 hours of community service when he's.
I absolutely agree with you. This is setting him up for failure since clearly he's got probation violations, and with his significant criminal history record, I'm going to reject the plea offer. And would you like to arraign the case and further notice the matter for trial?
Yes.
Okay. Will you be entering a not guilty plea pursuant to a waiver of arraignment, or shall I arraign the case?
I will file the waiver of arraignment and.
Mr. Williams, your attorney, Ms. Atay, will be entering a not guilty plea on your behalf. Your case is going to be further noticed for a trial. Your present bond is $6,500 as set by Judge Mincy. You are required to stay away from all Marta property and have no contact with Brandy Williams and Ms. Ramirez. Thank you.
So when is my next court date?
Is going to be sent to you by the division judge. And in this particular matter, it will be Judge Patsy Porter. Thank you. All right, jail court iPhone, who do we have, please?
We have position number 23, Mr. Troy Matt.
And 23 is represented by, oh, that is the conflict case, yes. Mr. Troy Mathis, yes, sir. My name is Judge Long. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. I believe you are represented by Mr. Gerald Bray. Would that be correct? Is that your attorney's name?
I don't know.
Okay. Troy Mathis is accused of battery, family violence from June 25th, 2023. His counsel is conflict, and your attorney, Gerald Bray, is not present in the courtroom. So your case is going to have to be reset to July 11th for Mr. Bray to contact you and present whatever information he's received from the prosecution, or to decide whether you want to enter a not guilty plea and further notice the case for trial. Do you understand, sir?
Yes, ma'am. I have an attorney for the battery case. I've been on the probation, the pretrial release for a whole year, almost. I did my anger management classes. I did everything I was supposed to do. But I got picked up on a warrant recently, and I guess the bond was revoked. But my attorney was Scott Smith.
Okay. Let me see.
I paid for him.
Your attorney is Gerald Bray. I've got Keith Cook. You have an attorney, Scott Smith. Yeah. All right. Ms. Champion, we have 4 attorneys listed for Mr. Troy Mathis, and he was arrested on a failure to comply with pretrial releases warrant. Your next court date is going to be July 11th, and one or all these attorneys are going to be contacted. I have Gerald Bray or Scott Smith.
I'm sorry, Your Honor. Gerald Bray has to withdraw from this case as we represent the alleged victim in Mr. Mathis' felony matter.
Okay, so Keith Cook is with PD's office. Scott Smith, is he with PD's office?
I'm not sure, Your Honor. I don't know everyone in the PD. He's a private attorney. Okay, Mr. Bartels is saying he's a private attorney.
All right.
But
So
our office does have to withdraw.
All right, in that case, Mr. Mathis, as far as you know, your attorney is Scott Smith?
Yes, ma'am. May I get like they gave me a bond.
We gave you a release bond, but you did not comply, and that's why you've got a $3,000 surety bond right now.
Right. I don't have all the money. I get a disability check every month, but I can't reach nobody from in here.
Okay, so we're going to reset the case to July 11th. We will contact attorney Scott Smith and have him available to address you at that time. Your present bond for failure to comply with the requirements of pretrial services is a $3,000 surety bond. Thank you.
Next, we can go to position number 5 on the add-on calendar. Upstairs.
Position 5. Chad Murray, would that be correct? And who represent Ms. Vigiletti? Is that your client?
Yes, Judge.
All right. This is 24 CR 3635C. State versus Chad Allen Murray. Mr. Murray, you have been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, have we got an update from PAD or diversion?
So, Your Honor, Mr. Murray was accepted into PAD. I do have the acceptance letter. I did share that with the solicitors. I just have not heard back yet. Mr. Ham, perhaps you have an update on whether that is an acceptable resolution to this case?
I have not heard back from Shelley, but based upon the information that you provided, I believe that that may be appropriate.
So was that a yes, Mr. Ham? You're agreeing with the defense's recommendation?
Yes, Your Honor.
Okay, so what's the recommendation, Ms. Vigiletti?
Your Honor, we're requesting diversion in this case, and PAD has agreed to come pick him up from the jail, and they'll be placing him in housing and getting him some support.
He has 3 open DeKalb County cases. How is that going to be resolved?
Your Honor, I'm sorry, I may have missed. Does he have a hold in DeKalb?
Chad Allen Murray, he had first appearance on June 11th. GCIC indicates that he has I don't know whether his probation violation case has been resolved in 23 SC 190185.
Yes, Your Honor, that will be resolved. He's on the calendar for that to be resolved July 5th.
Then he has 3 open DeKalb theft cases. He's got 46 arrest cycles. It's a lot.
Your Honor, it's my understanding from Mr. Murray that the DeKalb cases have been resolved. They don't seem to be holding him. I can certainly check on this and if we need
that was from June 11th. Ms. Bostic, do we have anything holding Mr. Murray at the present time? Or if you know of any open cases in DeKalb?
I don't have a secondary calendar for Murray. What's his booking number?
I can give you the booking number. It's 240-9669.
I mean, I can't agree to a release order if he's got holds.
Probation violation. Murray. Chad Murray. It's just a probation violation on his booking.
Okay. Miss Vigiletti, when's the probation hearing?
It is July 5th, Your Honor.
Okay, we will see him on July 11th. At that time, once the probation is resolved, I will consider a release order.
Is July 9th possible, Your Honor? I believe.
Oh, sorry, July 9th.
Okay.
I'm so sorry. My date's July 11th, so that's my default date. All right, July 9th. At which point then we will consider the release order.
Okay, thank you, Your Honor.
Your Honor, they just put me on probation for those 3 cases and made them concurrent. I came from the cab to here.
Yeah.
Listen to your attorney. Listen to your attorney.
Is because while we think your cases are going to be resolved on your felony on July 5th, this judge can't sign an order based on what's going to happen in another case. So she has to see what happens there first so she can sign a release order releasing you to PAD. So the 9th is the next available date to do that, to do the diversion, okay?
Thank you.
Thank you, Judge.
Next, we have position number 4, Mr. Michael Hall.
This is State versus Michael Hall, 24 CR 001-458E. Mr. Hall is accused of simple battery from March 27th, 2024. Mr. Hall, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Ms. Vigiletti. Ms. Vigiletti, are we ready to proceed with a plea, or will this be non-negotiated?
I believe this will be non-negotiated, Your Honor.
Okay. May I place you under oath, Mr. Hall? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Ham, what is the recommendation for Mr. Hall?
Yes, Your Honor, the recommendation for Mr. Hall is 12 months to serve 184 days, credit for the time served 92 days, balance to be served on probation, to stay away from, no further contact with Brenda Shaver, and to stay away from 267 Marietta Street, and to complete 8 weeks of anger management.
Serve 184 days, credit for time served 92 days, so that would essentially complete this jail time and he'll be on probation. Ms. Vigiletti, what's the counter?
Yes, Your Honor. I spoke with Mr. Hall yesterday, and my primary concern is his ability to complete the 8 weeks of anger management. As you are aware, Mr. Hall was initially put on the 11 a.m. calendar due to the nature of the offense and his mental state when he first came into the jail. And since then, he has been doing much better. He is on some very necessary medication, and we've discussed he has a plan for how to keep that medication. He knows where he's going to get it, and he knows, that he needs to stay on it. He was very apologetic yesterday for what happened. I'm certainly not requesting a removal of the 8 weeks anger management because this wasn't a terrible incident. I'm wondering if he'd be willing to swap it with compliance with his mental health medication, because since he has been on the meds, I mean, that seems to have made all the difference. He's clear on what happened, very apologetic. He's going to be going to Gateway right when he leaves the jail to get shelter. He was getting disability income, but he's not getting that anymore. And so he has a lot to do when he gets out of the jail. He's going to Gateway, he's getting a shelter placement, he's going to 10 Park Place to make sure he's staying on those meds. And he has a plan and he's ready to do it. But adding classes that cost money on top of that for a person with absolutely zero income who, as you're aware, when you need to restart your SSI, that could take months and months. So he has no income for the foreseeable future. I do think it would be quite difficult to complete those classes.
Mr. Ham, have you conferred with the alleged victim to see if she is comfortable with this recommendation? Or has victim advocates received any feedback?
1 second, Your Honor. Your Honor, no, we have not been able to reach the victim in, well, 1 second. I'm looking at no, this is the add-on calendar, right?
Right.
Yes.
Yep. Nope. Wrong calendar. Sorry. 1 second. I need to confirm with our victim witness advocate on the add-on calendar. I don't have any notes as of yet.
Understood.
This is already deal, bro.
Your Honor, I'm not sure if I mentioned this, but of course, Mr. Hall would be happy to comply with the no contact order and staying away from the incident location, the hotel on Marietta Street.
I understand, but it is still a alleged battery charge, so.
Yes, absolutely.
Miss Maldonado, any feedback? You can even put that in the chat to me and to Mr. Ham if you want. Any updates, Mr. Ham?
No, Your Honor, we did initially make contact with the victim. She confirmed everything that happened in the warrants. She said that she never received her phone or her bag back from the defendant. She does not live in that area. She's not from that area. And she said that she has since left the state of Georgia, and that all she wanted at that point in time when we contacted her, which was back in March of 2024, was that she had no further contact with the defendant.
All right, thank you. Ms. Vigiletti, it will be 12 months to serve 184 days, credit for time served 92 days, no contact with Brenda Shaver, and stay away from 267 Marietta Street. In lieu of the 8 weeks of anger management classes, he needs to complete 80 hours of voluntary community service and comply with all MH treatment and medication. He will report to probation every month. I will waive his probation fees, but he cannot afford to be arrested again.
Understood, Your Honor. Thank you.
Is that something your client would like to accept? Mr. Michael Hall, please unmute. Did you understand the court's recommendation?
Yes, ma'am.
You will report to probation every month. You must do 80 hours of community service. Would you like to move forward with your plea?
Yes, ma'am.
Okay. Ms. Vigilante, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor.
Okay. Mr. Hall, have you consumed any medication or alcohol recently?
Oh, no, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am. Where I report to probation to?
I will tell you very soon.
Okay.
But right now, you need to listen to my question. If you don't understand it, you must say, I don't understand, okay?
Okay.
Now, is anyone forcing you to plead guilty today?
No, ma'am.
Are you doing it freely and willingly and knowingly?
Yes, ma'am.
If you decide to plead guilty to simple battery, you will not get a trial in front of a judge or a jury. You will not confront your accuser. You will not be able to challenge the evidence brought against you, and the prosecutor will not have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery?
Guilty.
Your sentence is 12 months to serve 184 days, credit for time served 92 days. If you have no other cases holding you, you will be released within 24 hours. Upon your release, you must go straight to Gateway to get your housing squared away. On Monday, July 1st, you must report to probation, which is located at 132 Mitchell Street in downtown Atlanta. You will report to probation every month. You will complete 80 hours of community service at any nonprofit agency. You can also do it at Gateway if you want to do it that way. You must continue with your mental health treatment and be compliant with all medication and treatment. Do you understand?
Yes, ma'am.
I will waive your probation fees, but you must report every month. If you don't report, you will be back in jail. Understood?
Yes, ma'am.
All right, thank you.
Okay, yeah, she has a story. Okay.
Next, we have position,
iPhone.
we have position number 25, Mr. Patrick.
Miss Position 25 is going to be reset to July 2nd, 2024 for Mr. Patrick to speak to his Conflict Counsel.
Gotti, can you check the chat?
Deputy, did you get that? All right, this case is reset. July 2nd, his attorney is not present.
Okay.
Good afternoon, Your Honor. Good morning, Your Honor. ACDC is ready.
Who do you have?
I have, starting with position 4, Ms. Chapin. Actually, I don't see Attorney McLean. We can do Ms. O.
He's there.
Oh, he is? Okay.
Morning, Your Honor. Good morning.
Yes, Ms. Chapin is the negotiated plea, Your Honor.
Ann Chafin is accused of simple battery family violence from December 2nd, 2016 under case 17 CR 15224E. Ms. Chafin, you've been advised of your right to remain silent and your attorney is Mr. McLean. May I place you under oath for purposes of the plea? Do you, other right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Mr. Hare?
Yes, Your Honor. State's recommendation for position 4 is 12 months to serve 24 days, credit for the time served, 12 days, the balance to be served on probation, to complete 8 weeks of anger management, to have no further violent contact with Christina Goodpasture, to have no firearms, and the state is allowable to probation to terminate upon completion of all conditions.
Okay. Ms. McLean, does your client accept these terms and do you stipulate to the factual basis, venue, and ID?
She does, Your Honor. For the purpose of the plea, we also stipulate.
Okay. Ms. Chafin, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood the proceedings in your case so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And are you entering a plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to come back to court with an attorney to confront your accuser, challenge the evidence brought against you, present any defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery?
Guilty.
Violence? Okay. I accept your guilty plea. Your sentence is 12 months to serve 24 days, credit for time served 12 days. The remainder of the time you'll be on probation. You will report to probation on Monday, July 1st before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will enroll and complete 8 anger management classes. You must enroll in those classes within 45 days of being released. You're also to have no violent contact with Christina Goodpasture, which means that you can communicate with this lady, but you cannot have any physical or verbal altercations with her. If you complete your 8 weeks of anger management and you're up to date with your probation fees, your probation will terminate.
Yes, ma'am.
Thank you.
Next, Ms. Milton, we can jump from ACDC to courtroom 2.
Courtroom 2, who do we have?
We can go to position number 33, Mr. Javin Stephens. Stephens.
33. All right, sorry for the moment. 33.
I apologize, Judge Law. Before you, can someone tell me where Mr. Copeland is in the rotation, if possible?
We're here, right here in medical. I just got him.
Thank
Okay.
you.
Position 1.
Thank you.
We're on position 33, Your Honor.
Understood. Thank you. Position 33. Is this Javier Stevens?
Yes.
All right, Miss Ate, did you need additional time or are we ready to move forward?
We're ready to move forward. I was able to speak with him again this morning. he is gonna enter a not guilty plea and we do have a bond request.
Okay. Javier Stevens is accused of simple battery under accusation 24 CR 997J. Mr. Stevens, you've been advised of your right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Atay represents you. Your attorney is going to file, I'm sorry, did you want to file a waiver or would you like me to arraign the case?
I'll file a waiver.
All right. Mr. Stevens, your attorney will be entering a not guilty plea on your behalf. And presently, you do have a bond. I'm sorry, I'm trying to get to the particular case. And you may proceed with your bond argument, Ms. Atay.
Yes, Your Honor. Mr. Stevens, he's 18 years old. He's lived in Georgia all his life. He did just graduate from high school in May. I did not see a criminal history report, but I believe that he has no adult history. We can ask pre-trial. I know that he does have a hold in Rockdale, and he says that's why he was arrested, because of that hold, and it is a juvenile hold with the Department of Juvenile Justice in Rockdale. He has been in jail for 14 days. His bond is set at $5,000 right now. So, and I have spoken with his mother, who he lives with, and I would ask for a signature bond through pretrial services with the parent co-signer.
Looks like he was arrested on new charges.
Yes.
And it's a $22,000 bond.
I think it's well, 22,000 because with this $5,000 bond, but he has.
He has $17,000 in this new case.
Yes, which is.
So that's why he's in jail.
Well, and this one.
This one's just a surrender of a signature bond because of the new arrest.
So it's a $5,000 bond here that I'm.
Yeah, it was $5,000 signature bond, but pretrial surrendered the signature bond because of his subsequent arrests for reckless driving, operating a vehicle on an instructional permit, and felony fleeing and attempting to elude a police officer from June 14th, 2024. So you're asking me to reinstate his signature bond?
Yes.
All right. Ms. Mulcahy, any objection?
Yes, Your Honor, he already had a signature bond. He was out on that and then proceeded to commit another crime. And I see that the Rockdale County case that he has was also for simple battery. So that, in conjunction with the facts in this case, in which he is accused of beating the victim and she was pregnant, the state's recommendation is that the bond stay the same.
All right. Anything else to add, Ms. Atay?
Well, and Your Honor, he does firmly deny the allegations as stated in the warrant. He states that he's the one who called the police on this incident. And I don't know about the Rockdale County case, but I believe it's a juvenile case.
Oh, I'm not concerned. I'm just looking at his new felony arrest, and I'm looking at the accusation. I didn't set the signature bond. I guess this might have been a bind over, but his current bond for this case is going to be $2,500. It's going to be a surety bond. No further contact with Jalivia Aikens, Jalivia Aikens, Aikens. He's to stay away from her home, from her work, or wherever she's physically situated, not communicate with her in any way, form, or manner. No illegal drugs, no alcohol, and no weapons. And he is to make sure that he maintains a current mailing address with the courts at all times. And you say he's over 18, right?
Yes, Your Honor.
So he can sign a surety contract. Thank you. He still has his felony matter to address in Superior Court. This case is going to be further notice for trial. All right, medical. I am moving on to State versus Dontarius Copeland. This is on the add-on calendar. Mr. Kilgo, there you are. Thank you, Mr. Kilgo. I apologize for the delay, but on an SAP calendar, we're at the mercy of the availability of the inmates at different locations.
I totally understand, Judge.
Thank you, sir. All right, this is State versus Dontarius Copeland, 20 CR 002182C. Mr. Copeland has been found guilty of DUI pursuant to a jury trial from which he was sentenced to serve time at the Fulton County Jail. Apparently, his attorney has filed an emergency motion to consider obtaining medical services for Mr. Copeland. Mr. Copeland, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Kilgo. Mr. Kilgo, you may proceed.
Thank you, Your Honor. I appreciate you allowing us to be heard this morning. So as you recall, on May 31st, the jury convicted Mr. Copeland and the court sentenced him to 120 days to serve. At that point, he was taken into custody by the marshals and was taken over to Rice Street. About 2 hours after we left court, I received a call from Mr. Copeland indicating that he had been released. During his in-processing, there was an injury that was discovered, and we're not implying at all that it was the jail staff that did this. Apparently, it was a pre-existing injury to his arm. They would not take him into custody that day. They released him and said, come back on June the 4th. The following Saturday, June the 1st, I'm sorry, Sunday, June the 2nd, he went to Piedmont Emergency, and I did send to Ms. Strong some medical documents. I had mentioned in my motion that I didn't want to file those, but I'd be happy to give those in camera, and I've also sent them over to Mr. Ham as well.
All right, as long as Mr. Ham has them, that will be good. Thank you.
Okay, good. So he was seen at Piedmont, where he was diagnosed with a fracture in his left arm, or a humerus fracture in his left arm. He was put into a sling and was set to follow up with an orthopedic surgeon on June the 5th. However, both the jail and then the court, you issued an amended order, I think on the 31st, requiring you to report by noon on June the 4th, which he did. I actually met him at the jail. We turned him in. He had his medical documentation with him, and his arm was in a sling. It's 23 days later now. He is on the medical unit, but according to my client, he has not been treated at all for his arm. As you can see, he's still in a sling. He hasn't been put in a cast. I also understand there may be some security issues with placing casts. I don't know how the jail does that. He has been and this comes both from him and from his mother, Mrs. Copeland, who's also on the Zoom at this time. He has been x-rayed twice. The first time they x-rayed his chest and not his arm. The second time they x-rayed his wrist and not the portion of his arm that was broken. At the time he turned himself in, the documentation indicated that he had a follow-up appointment the following day with that orthopedic surgeon, June the 5th. Prior to me filing the emergency motion last week, Mr. Copeland was told by jail staff that it would be late July or early August before he could see an orthopedic surgeon about his arm.
No, that would be when his jail time is completed and he'll be placed on probation. Yes.
Right. Well, it was explained to me that was the earliest that he would see anybody orthopedically about his arm. You may be right about that. That's how it was explained to me. I think that's how he understood it.
Okay.
I can tell you now that the only medication he's been given, I believe, is naproxen, which is an analgesic. He began complaining last week of pain radiating down to his hand and now across his chest and his back. And of course, he and myself and his parents are concerned that there's a bigger issue. He can't move his arm at all, as I understand.
Mr. Kilgo, you know and I know that he was in the courtroom and he never disclosed this information prior to sentencing.
I'm well aware of that, Judge.
And you also understand that he only disclosed it after he was in custody en route to the jail when he disclosed it to the marshal's department. Can you and I agree on that?
Absolutely can agree on
Okay.
that.
So, and then I issued an amended order requiring him not to be brought to jail, but for him to privately seek medical services. Can you and
And
I
he did
agree
do
on that? Okay.
Yes, he did do that.
And at the time that he received medical services, he was not put in a cast. Can you and I agree on that?
We can agree on that.
Okay, and he did not go to emergency treatment also to get a cast, as we all know, one can receive.
He did go to emergency treatment, but they didn't put a cast on him, I think, because he was supposed to follow up with the surgeon. That was going to be the day after he had
He's got a fracture to an arm and no cast was imposed in an emergency room. Is that what you're telling me?
Yes, ma'am, that's what I'm telling you.
Do you have a doctor or a medical provider who is able to testify to that?
I don't have one with me, but I certainly can bring one to the court if we need to.
Okay. Mr. Ham? Okay, go
I'm
ahead,
sorry.
Mr. Kugel.
I'm sorry, Judge. Yes. So the documentation that I've provided to the court and to Mr. Ham has the name of the surgeon that he was supposed to meet with on the 5th. I can only assume that he wasn't placed in a cast in order to facilitate that.
I'm not making any presumptions.
Okay.
All right. I just want to know why, if a cast was required, why was it not done before when I gave him time to seek medical services? Because
I don't know. Can't speak to that.
okay, can't speak to that. So I am certainly curious as to the emergency basis then. Mr. Ham, have you had an opportunity to review the medical documents or receive any kind of input?
Yes, sure. And I was able to review the medical documents. It seems as if he did have a follow-up with the orthopedic surgeon on June 5th, 2024, which would have been the day after he turned himself in. And I did review the brief that was provided or filed by the defense in this case. The state, however, is under the mindset that there was no indication of any fracture prior to up until the time he was in custody. And certainly if directed by the court, the jail could transport him to Grady Healthcare if it's deemed necessary to obtain any type of treatment that may be possible. It doesn't necessarily require that he be released from custody. I do believe this case was heard by Your Honor. In trial, he has a history of DUIs, and I believe that's one of the reasons why Your Honor gave him the amount of time that you sentenced him to, was because of his history and because of this particular incident. I don't see any reason as to why a fracture should allow him to be released from Your Honor's sentence. So the state would be opposed to the defense request.
All right. Medical, since we are the medical unit deputy, do we have a doctor on staff?
I'm quite sure there is one. I didn't see one at the time I've gotten him. He was outside getting ready to seek medical treatment as well.
I'm sorry?
He was out getting ready to seek medical treatment before I pulled him.
Who, Mr. Copeland?
Yes,
Okay.
Mr. Copeland.
All right, Mr. Kilgo, anything else?
Judge, I think we just want to have his arm seen about. If we can get him to a doctor, I even discussed with him and with his mother, it's entirely possible that you would have him transported to Grady. He's very worried about this arm. You know, at this point, it's entirely possible they may have to do something surgically to fix him. So we just want to make sure he gets that treatment that he needs.
All right. Like I said, I gave him ample time. I don't understand the reasons why treatment was not provided during the time when before he was supposed to report to the jail. Furthermore, the court is very perplexed why he didn't disclose that at the time he was being sentenced, that his arm was hurting. But soon after he was in custody, in the privacy of the holding location, he suddenly disclosed this pain in this left arm. I am very, very curious about all the situation. I don't place a lot of credibility right now on this situation. So I am going to require the doctor at the medical unit at the jail to review Mr. Copeland's situation. And if he believes that he needs to be transported to Grady, then then I will listen to the doctor's recommendation to see if I can issue an interim release order for him to go to seek medical treatment on his own recognizance and then report back to the jail to continue his sentence.
Okay. And I would say, Judge, I don't think it's an attempt to obfuscate.
I don't know, Mr. Kilgo. Like I said, I have just articulated the series of events that have occurred. If I have a broken arm, that's the first thing I'll be shouting out in open court. The fact that Mr. Copeland decided to remain silent throughout his trial, throughout his sentencing.
Well, I'm not sure that he even knew that it was broken. I think during the process of being medically processed, if you can use that word twice, he said, look, I've got to, I have a problem with my arm, if you're asking. And that's when they determined, well, it could be a break. They released him. He went to the doctor within, I think, 36 hours. And the doctor said, oh, yeah, you do have a broken arm. I don't think he knew before the doctor told him that Sunday that he had a broken arm. So I don't think it's not even something he mentioned to me during the trial. It just happened when he called me. He said, hey, I don't know if you noticed, but I haven't really been using my left arm. I may have injured it. I'm going to go to the doctor. And he did.
I totally accept that I don't see the emergency basis. So I am going to have the doctor, the jail staff, if he believes it's an emergency, he can definitely inform the sheriff who can transport him to Grady Hospital on an emergency basis. Thank you.
As long as we get the medical help, Judge. Thank you.
All right. I'm going to issue an order requesting that the physician on staff at the Fulton County Jail review Mr. Copeland's situation and then exercise his medical discretion as to whether he needs to be sent to Grady immediately or whether the court should allow for an interim release for him to seek medical treatment. Thank you.
Thank you, Judge. Thank you, Mr. Ham.
Next case, please.
We can go to position number 34. Mr. Thompson.
This is State versus Demetrish Thompson, case 22 CR 006-053F. Mr. Thompson was accused of driving under the influence of alcohol less safe, failure to maintain lane, and possession of an open alcohol container from January 8th, 2021. Mr. Thompson, you've been advised of your right to remain silent, and your attorney is Ms. Attain. This is going to be a non-negotiated plea. Would that still be the situation?
No, Your Honor. He has decided to enter a not guilty plea. Our office has just found out that I thought it was a private attorney, but he's actually represented by conflict counsel on another case. And I do believe that he needs to be represented by conflict counsel. However, I think on this case, what's holding him is an FTA, and I am going to request make a request to lift that FTA or lower the $6,000 amount on the FTA without getting into the facts of the case.
Well, unfortunately, you can't represent him if he's got to have conflict counsel. And who was his conflict counsel?
Kenneth Mitchell, who he states is not on the case anymore. I didn't know, I thought it was a private attorney. I didn't know that it was conflict counsel. And I guess he has conflict counsel on another case, but he was not conflicted on.
All right. So let me see. He was accused on September 8th, 2022.
Okay, so
1 second, please. No order was issued. He failed to appear in court before Judge Richardson on April 26, 2023. A bench warrant was issued. Mr. Thompson was arrested on the bench warrant and he made bond on July 22nd, 2023. He had another bond surrender on June 19th, 2024. And hence we are now, so this is his second FTA.
Yes, Your Honor, and I did confirm with the Atlantic bonding representative, she stated that they have never, they don't receive notice. My client, no, not my client, but Mr. Thompson states that he hasn't received notice for any of these trials. I mean, he has paid over $10,000 in bond money and would show up in court if he had any notice, but he doesn't have any notice. And also in the felony case, the 23 SC 189542, the bonds company has even provided me with documentation that they stated to the court that they never received notice for that. And that's a $50,000 bond that he paid.
Let's see now. His present bond is $6,000 on his second failure to appear. And the current address we have is 500 Northside Circle.
And that's correct.
So when was this address updated? Because previously we had a 1003 Three Corners Parkway.
And I think that he updated that. I don't think it was updated recently. It was updated years ago. I think he's been out of that.
Yeah, we don't have a return to sender between July 22nd, 2023 and June 19th, 2024. I mean, I'm trying to understand.
Bonding
point.
Also stated that they haven't received notice.
That's neither here nor there.
And he states that Kenneth Mitchell, who I understand is conflict counsel. I'm not sure if he's a private.
I can appoint Mr. Dennis Murphy. Mr. Murphy?
Taking the class.
Mr. Dennis Murphy? Well, he's on Zoom, so.
No, so the class is online.
Mr. Thompson has got a $56,000 bond presently holding him at the Fulton County Jail. Furthermore, as a result of his felony arrest. He also has part of that $56,000 is a $6,000 surety bond. I will appoint either Mr. Dennis Murphy, I will give him the case number to represent Mr. Thompson, and we will readdress his case on July 9th, 2024. Thank you. And since Mr. Thompson, I'm not going to accept your not guilty plea at the present time because Ms. Atay is not qualified to enter a not guilty plea on your behalf. You need to be represented by a conflict counsel. So your next court date is July 9th. We'll let Mr. Dennis Murphy know that he needs to speak to you, and we'll address it at that time. Thank you.
Very odd, very odd.
Next case, please. ACDC, who do we have? Or courtroom 2, whoever beats it to the screen.
Yeah, we can go to position number 14 and 15, Mr. Derek Hickle.
Okay, Mr. Derek Hickle.
So nice.
Mr. McLean, is that your client?
Yes, Your Honor. The correct spelling of his last name happens to be Heikell. His first name is spelled correctly.
H-E?
Heikell. It's pronounced Heikel.
Heikel. Okay, got it. Thank you. Mr. Derek Heikel, listed on the accusation as Derek Hickle. Case number is, he's got a bench warrant, 24 FTA 000770 from February 21st, 2024. His underlying case is for battery, family violence from December 18th, 2023. Case number 23 CR 8059J. Mr. Heikel, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. I understand this is going to be a negotiated plea. Is that still on the table?
Yes.
Okay, Mr. Heichel, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, thank you. Mr. Ham, we are addressing Mr. Heichel, position 15. What's the state's
Yes, sir.
recommendation?
Yes, Your Honor, for position 15, the state's recommendation for the charge of battery family violence is 12 months to serve 30 days, credit for the time already served 2 to 12 days, balance to be served on probation, to stay away from 1856 Wells Drive Southwest, to have no further violent contact with Jeremy Marshall, to take a family violence intervention program, to complete 40 hours of community service, to have no firearms on his persons, and to complete an alcohol and drug evaluation and any treatment that's deemed necessary. As it relates to position 14, the state will move to no Parsonage County.
Okay. So, okay, I see that. And I just want to confirm, so he will have 3 more days to serve at the Fulton County Jail. Would that be correct?
Yes, Your Honor.
Mr. McLean, is that correct?
That's correct.
On the McLean math tachometer. Okay, so. All right. And do you stipulate to the factual basis, venue, and ID, sir?
For the purposes of the plea, we do.
All right. Mr. Heichel, have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your case so far?
Yes.
You need to answer a little louder, sir.
Yes, yes, I do.
Are you satisfied with your legal services?
Yes.
And is anyone forcing you or inducing you to take this plea offer today?
No.
If you decide to accept this plea offer, you would have to give up your constitutional right to a trial before a judge or a jury. You will not get the chance to confront your accuser, challenge the evidence brought against you, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of battery family violence from December 18th, 2023?
Yes.
Your sentence is 12 months to serve 30 days, credit for time served 12 days. You have 3 more days to serve at the Fulton County Jail, which will be Friday, Saturday, and Sunday. Once you are released, you must report to the Fulton County Probation on Tuesday, July 2nd, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete a domestic violence intervention program, and you must enroll in that program within 45 days of being released. You will also complete an alcohol and drug evaluation and submit yourself to any treatment, and you must make an appointment and complete that within 30 days of being released. At all times, you have to have no violent contact with Jeremy Marshall, and you have to stay away from 1856 Wells Drive in Southwest Atlanta. You're also required to do 40 hours of voluntary community service at any nonprofit agency, which you can do, but it cannot be a church and it cannot be a school. You must do a minimum of 5 hours per month and 5 hours every month thereafter. At all times, you're not allowed to possess any weapons or any firearms. That concludes your sentence.
Your Honor, let me mention, he's got to go to Paulding County first, and I explained to him within about 3 business days or no longer than that. As soon as he's released, get over there to Mitchell Street.
All right. In that case, then his probation's deferred until he's released from Paulding County. Thank you.
Thank you.
Mr. Murphy,
I'll sign it on.
while we were still addressing SAP, we have a case that's going to be reset to July 9th. And if I can give you the case number, it's 22 CR 006053F. Demetrish, spelled Dametrish, last name Thompson, common spelling. Accused of DUI, failure to maintain lane, and possession of open alcohol container. He requires a conflict counsel. Do you have any objection to this appointment?
No objection, Judge. And that was 22 CR 006.
053F.
Duly noted.
His
And
case
so it'll
his case is reset to SAP July 9th at 9 a.m.
Duly noted, Judge. I'll accept the appointment.
Appreciate it. Thank you. ACDC, are we ready?
Are we completely finished with courtroom 2, Your Honor?
I don't think so. I'm just waiting for someone to show up. Courtroom 2, do you have someone ready or shall I move on to ACDC?
Your Honor, I think we can move on to ACDC.
All right, Deputy Milton?
Position 16 through 18, Hicks.
Your Honor, Ms. Hicks would like to enter a negotiated plea this morning.
Thank you. This is Ikera Hicks. On position 16, her case is 23 CR 64318, accused of criminal trespass from October 6, 2023. Ms. Hicks has a second charge of criminal trespass under accusation 23 CR 6782H from October 28, 2023. She also has a bench warrant 24 FTA 773 from May 17th, 2024. Ms. Hicks, you have been advised of your right to remain silent. Your attorney is Ms. Vigiletti. May I place you under oath for purposes of the plea? Other right hand, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Ham, what's the recommendation for Ms. Hicks?
Yes, Your Honor. For position 16, the state's recommendation is time served. She's completed 11 days in custody from October 19th through the 20th of 2023 and from June 16th until present of 2024. For position 17, the state's recommendation is 12 months, served 8 days, credit for time served 4 days, the balance suspended, to stay away from all MARTA stations, which is a permanent ban, Your Honor. And as it relates for position 18, the state will move to Norcross.
Ms. Vigiletti, does your client agree to these terms and do you stipulate to the factual basis, venue, and ID?
We do stipulate, Your Honor, and I presume the permanent ban is coming from MARTA, right?
That would be correct.
Yes, and we did discuss that, and we've discussed the possibility of obtaining a bicycle. So I think we're clear, Your Honor.
Ms. Hicks, have you consumed any medicine or alcohol recently?
Nothing. No, ma'am.
And have you understood everything that's going on with your case?
Yes, ma'am.
Have you understood what your attorney has explained to you?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your right to go back to court and have a trial in front of a judge or a jury. You will not have the assistance of counsel in a court of law to confront your accuser, to challenge the evidence that would be brought against you, and to have the prosecutor prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the 2 counts of criminal trespass in these 2 cases?
Guilty.
Your sentence for the criminal trespass from October 2023 is to serve 11 days, and you have completed 11 days, so that case is over. With regards to the criminal trespass from October 28th, 2023, your sentence is 12 months to serve 8 days, credit for time served 4 days, balance suspended. Your jail time for that case is also over. You must stay away from all MARTA property forever.
Yes, ma'am.
You're not allowed on any MARTA buses or trains pursuant to the ban issued by MARTA Services. Thank you.
Ma'am.
Next, we have position 19 and 20, Tamika Hill.
And Ms. Hicks' bench warrant is null prost.
Bench warrant was not for.
On position 19 and 20, Tamika Hill is accused of willful obstruction of an officer and disorderly conduct from December 23rd, 2023, under accusation 23 CR 8227C. She has a bench warrant from June 6, 2024, under 24 FTA 774. Ms. Hill, you've been advised of your right to remain silent, and your attorney is going to be Ms. Vigiletti. May I place you under oath?
Yes.
Please raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Han, what is the recommendation for Ms. Hill?
Yes, Your Honor. For position 19, count 1, willful obstruction of a law enforcement officer, the state's recommendation is 12 months to serve 28 days, credit for the time served 14 days, balance to be served on probation, and to pay a $300 fine. For count 2, disorderly conduct, state's recommendation is 12 months probation to run concurrent with count 1 and to stay away from QLS Villa, located at 4020 Danforth Road, Southwest Atlanta, Georgia, in Fulton County. As it relates to position number 20, the state will move to non-press that case.
Ms. Vigilante, are those the terms to which your client has agreed, and do you so stipulate?
They are, Your Honor, and we do. I did want to ask, Ms. Hill is on SSI income. It's very, very limited. She's paying all of her expenses from SSI income. She will, of course, be making payments on this $300 fine. So if Your Honor would consider waiving her probation fees and perhaps allowing the probation to go non-reporting upon payment of that fine, I think that would be extremely helpful to Ms. Hill.
I can amend this to 45 hours of community service and waive for probation fees for the months of July and August. And if she completes the 45 hours of community service, then it will be non-reporting.
Okay, we did not discuss the possibility of community service.
I can ask her now. Ms. Hill, you can either pay a $300 fine while on probation, or you can do 45 hours of community service at any
I would pay the $300 fine.
Okay.
She
All
does
right.
have significant disabilities, Your Honor, so I think the fine makes sense as long as she can make the payments on it.
Then the probation fees will be waived for the months of June up to end of August. If she pays off the fine by then, her probation will be non-reporting. Otherwise, it will continue, and her probation fees need to be paid from September 1st onwards.
Understood. Thank you, Your Honor.
All right. Miss, and do you so stipulate, Miss Vigilante?
We do.
Thank you. Miss Hill, have you consumed any medicine or alcohol recently?
I received medicine.
All right. After consuming the medicine, are you still able to understand what's going on in your case?
Yes, Your Honor.
Are you able to understand your attorney, and are you satisfied with her legal services?
Yes, Your Honor.
Are you entering this plea willingly, knowingly, and voluntarily?
Willingly. Yes, Your Honor.
If you decide to plead guilty to these charges, you would have to give up your right to a trial in front of a judge or jury. You will not get the chance to confront your accuser, challenge the evidence brought against you, present any defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of disorderly conduct and one count of willful obstruction of an officer?
Guilty.
Your sentence for the willful obstruction is 12 months to serve 28 days, credit for time served 14 days. If you have no other holds, you'll be released within 24 hours, but you must report to probation on Monday, July 1st, before 3 p.m. While on probation, you will pay a $300 fine. Your probation fees will be waived up to and including the end of August 2024. You will start paying probation fees on September 1st, 2024.
Okay.
Unless you have completed paying your $300 fine before then your probation will be non-reporting. For disorderly conduct, your sentence is 12 months concurrent with count 1, and the requirement is that you stay away from QLS Villa at 4020 Danforth Road in Southwest Atlanta. Your bench warrant is null crossed. Thank you.
Thank you.
Yeah, we're in court today. Thank you.
Next, we have add-on 2 and 3. I'm sorry, add-on 6 and 7, no, whoa. Probation, probation. It's probation, position 3, Ms. Najee.
Okay.
Deputy Milton, can I ask quickly, is Shayla Owens still outsourced for medical care?
Well, let me make a phone call and I'll let you know.
Thank you so much.
Your Honor, on Ms. Najee's case, although we did reset that from a few weeks ago to check with the felony lawyers, it turns out, Your Honor, that they believe that they will be closer to or finish with the resolution of her felony matters by mid-August. And she does have 180 days left on probation. I spoke with the probation department, Ms. Allen, today, and she's okay with a reset. I would prefer a reset to mid to late August and see how everything shakes out on the felony case, Your Honor.
Just give me a moment. A case is reset to August 29th, 9 a.m.
And I'll let those other lawyers know. Thank you, Your Honor.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you.
All right, thank you.
All right, ACDC, do we have any other matters?
Yes, Your Honor. The question that Ms. Vigiletti asked, yes, she's still out.
Okay, thank you.
All right. Next, we have add-on position 2 and 3. Now, back up. Mr. Vincent Price, come on. That's position 26, Your Honor.
Thank you.
Have a seat right here, please, sir.
This is State versus Vincent Price under case number 24 CR 4055D. Mr. Price, please remember you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. These are charges of driving under the influence of alcohol, less safe, failure to maintain lane or improper lane change, and driving without a valid license on May 9th, 2021. Ms. Vigiletti, I understand that you want to argue for a dismissal. What is the basis?
Your Honor, actually, after submitting my announcements, Ms. McKickey provided documentation that this is actually a bind over, so it was accused within the statute of limitations in the city of Atlanta. So that resolves the possible statute of limitations issue. The issue that still remains for me as his attorney is that I don't have any information about what happened. I have a citation that just says DUI. I don't know if he got a blood test or a breathalyzer or a field test. I don't have a police report. I don't have enough information to adequately advise Mr. Price today. He has been in custody for 49 days. You know, and I'm not suggesting that it was anybody's fault or anybody intentionally waited to accuse this until he is very likely to be released. But he does have a hearing on what's holding him tomorrow. So he is very likely to be released tomorrow. So if Your Honor is willing to consider a signature bond on this, just with the understanding that I can't competently represent him today on this, I would greatly appreciate it. If otherwise, if Mr. Price is interested in taking a plea, I just won't be able to represent him. It would have to be pro se.
All right. Ms. Thomas?
Just like she say, they don't have no warrant on that DUI, and it's been like 3 years anyway, so she should just drop it. So, you know, that was she asking. That's what we were asking.
Request is denied. All right, moving on. The Ms. Thomas, Mr. Price has 3 probation violation matters and a foreign hold. Would Ms. Bostic or Ms. Thomas with probation advise us as to that status?
Got a foreign hold. What's you saying? A foreign hold? What you mean?
So, Mr. Price, in addition to improperly arguing for a dismissal, you've also been advised of your right to remain silent. And if you'd like to contribute to your demise, please feel free to waive your right to remain silent. Would you like to remain silent, or would you like to contribute to your demise?
What's demise?
Demise means to your detriment.
What's that? Detriment? What is
That
that?
means that every time you open your mouth and say something, you're going to end up being in deeper trouble with the court. Thank you.
Your Honor, I did reach out to Hateville. Mr. Price, you have a hold for in Hateville. I did reach out to them and they did confirm with me via email what that hold is for. He has an open case. It's 2 counts of disorderly conduct and 1 count of loitering.
Okay. And this is with Hateville Police Department?
Yes, so I do believe they will be picking him up.
I see.
Yeah, that's what I'm going on.
Yes.
Please be quiet.
And he's aware that that's where he's going next. And his felony probation hearing is scheduled for tomorrow.
Okay, so that's the hold that he has right now.
Yes,
Okay.
Your Honor.
Understood. Thank you. On the driving under the influence of alcohol less safe, that's going to be a $1,000 surety bond. On the failure to maintain lane and the driving without a valid license, each is going to be a $500 signature bond through the jail. He's got a split bond for $2,000. And no driving unless he has a valid driver's license, adequate insurance, and proper registration. And he's not to consume any alcohol and no illegal drugs. Would you like this to be reset to another SAP calendar, or would you? I think that would be best, considering you've just indicated you don't have enough information to move forward.
I really don't, Your Honor. If Mr. Price wanted to take a plea today, he would have to do so pro se. Otherwise, I would need more information in order to adequately advise him.
He's having his probation hearing tomorrow in Superior Court, so I'm going to reset this case to July 11th. Thank you.
Your Honor, it is my understanding from Mr. Price yesterday that he did want to take the plea if I was not able to address the statute of limitations issue. So I did just want to let the court know, because he is here and it would be his right. I don't want to be stopping him from taking a plea. That's not my job, so.
Understood. Please unmute Deputy Milken. Mr. Vincent Price, the Public Defense Office is not comfortable moving forward with this case because they don't have sufficient information about your DUI case in order to give you proper legal advice as to your legal options. So if you decide that you want to accept a plea offer from the state today and enter into a plea with regards to this DUI case, you would have to do so in a self-represented or pro se capacity. So presently, your bond is a $2,000 split bond, which means that you would have to pay on the DUI charge in order to be released after your probation hearing tomorrow in Superior Court. Otherwise, if you want to move forward with the plea hearing today in your misdemeanor DUI case, you would have to do so representing yourself, and the Public Defender's Office will withdraw from this case. How would you like? Please understand that if you choose to represent yourself, you are responsible for understanding the laws regarding your case and how it impacts the particular facts of your case, as well as how it may impact any other open cases you may have, as well as any residency issues, as well as your driver's license. How would you like to proceed?
Yeah, this is Paul. Yeah, hey, how are you doing?
Courtroom 2, please. Yeah. Mr. Price?
I thought you said she gave me a surety bond.
I've given you a surety bond on the DUI, yes.
So what you mean I sign a bond? I gotta pay for a bond, but I go to Hateville when I finish tomorrow. So why can't you just finish it today and I go to Hateville and report to whatever you're talking about?
I've already told you
I
so.
don't understand it.
All right, so right now, in your DUI case in Fulton County State Court, DUI misdemeanor case, are you following me?
Yes.
You have a surety bond on the DUI charge. In order to be released on that, you would have to pay the bond on that. Once you pay the bond, then Hateville Police Department will come and pick you up to address their charges in Hateville City. Tomorrow, you have your probation hearing on your felony case in Superior Court. I don't know what the outcome will be there.
So what you're saying then about me, I gotta go through misdemeanor court again for this right here?
You are in misdemeanor court. This is an open active case. It's still
But
open
if
and
I
it's still
can't pay,
active.
if I can't bond on the pay,
And you stay in jail until we're ready to address your case on July 11th.
I thought you said, it was gonna be taken care of today,
No, sir, I never said that.
July 11th.
Yes, sir, on your misdemeanor DUI case.
All right.
All right, Ms. Vigiletti, you may still continue representation. His next court date is July 11th, pending his release on bond. Please submit the revised bond order.
Your Honor, thank you.
Deputy Milton?
Next is position add-on 3 and 4. I mean, that's not everything, Your Honor. It's 2 and 3.
Ashton Green, how y'all doing this morning?
Fine, thank you, Mr. Green. Just 1 second, please.
This evening.
This is State versus Ashton Green. He's got 2 cases on our SAP add-on calendar, 23 CR 005-172E, and he's got a bench warrant, 24 FTA 000712. Mr. Green, you've been advised of your right to remain silent, and your attorney is going to be Ms. Vigiletti. Ms. Vigiletti, he's accused of theft by taking from August 3rd, 2023. How would you like to proceed?
Mr. Green would like to enter a negotiated plea this morning, Your Honor.
All right, Mr. Green, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Ham, this is Ashton Green on our add-on calendar. He's got a bench warrant. I'm assuming the state will null cross that if he moves forward with his plea.
Yes, Your Honor, that's correct.
And what's the
As it relates-
recommendation?
Sure. As it relates to position 2, Your Honor, that by taking state's recommendation is 12 months to serve 42 days, credit for the time served 21 days, balance to be served on probation, to complete an anti-theft course, to stay away from LOL Burger located at 2072 DeForest Ferry Road Northwest, and to complete 40 hours of community service. The state will also move to dismiss position number 3.
Ms. Vigiletti, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
We do, Your Honor. I did want to just relay this message because I've spoken to Mr. Green a couple of times now, and he did just want to make sure you know, Your Honor, that although this is something he did in the heat of the moment, it's not who he is. When we were discussing the possible ways to get this community service done, he actually told me about a lot of community service he's already doing, so I am confident he'll complete these terms quite quickly. He does a lot of community work in South Bolton, and just wanted everyone to know that. If Your Honor would consider, you know, he have to take the anti-theft class and participate in community service, the possibility of non-reporting status upon completion of the terms of his probation.
All right, Mr. Ham, any objection to non-reporting upon completion?
No objection, Your Honor.
All right.
Yeah.
And yes, Mr. Green, did you want to add something?
Yes, ma'am. I wanted the court to understand that I want to stay away from Ms. Brooks that's in that same office. Understand that I have just been railroaded by a woman that's in that same office, and I'm being put back on probation again in that same office. I just want that to be understood that it is a lot of crooked stuff that's going on in this system that need to stop towards a lot of people that come to these probation officers. And they also have their own personal reasons on why they send you to classes as well.
Understood, Mr. Green. Your Honor, what Mr. Green is talking about, we have actually heard a number of times. He was on probation previously where he was ordered to do family violence intervention program. And he tells me he was told by Officer Brooks that he had to take her class that she runs herself, and that he had to pay her directly, her side business directly, or her specific class. We have been told this before. That matter was resolved yesterday. His probation was terminated for that yesterday. And so it's not part of the plea today. And I plan to just call the probation office directly and see if it's possible for him to switch officers, because they have had this conflict in the past. But I do think it would be something that I can discuss with the probation officers.
Okay. Mr. and Miss Vigilante, you so stipulate?
We do, Your Honor.
Mr. Green, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case so far?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
Is anybody forcing you or inducing you to plead guilty to this charge today?
No, ma'am.
Are you doing so freely, willingly, and voluntarily?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity to challenge the evidence or confront your accuser in a court of law, not present any defenses or closing arguments, and also not have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by taking from August 3rd, 2023?
Guilty.
Your sentence is going to be 12 months to serve 42 days, credit for time served 21 days. If you have no other holds at the Fulton County Jail, you'll be released, but you must report to probation on Monday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. We have the probation supervisor, Ms. Thomas, on Zoom, and I'm sure she has taken down the statements that were made earlier and assigned the appropriate probation officer for your case. While you're on probation, you will complete an anti-theft class, and you must enroll in that class within 30 days of being released. You must also stay away from the LOL Burger at 2072 DeForest Avenue in Atlanta, Georgia. You will also complete 40 hours of voluntary community service with any nonprofit agency that's not a church and not a school. You must begin with a minimum of 5 hours per month and a minimum of 5 hours every month thereafter. That concludes your sentence. Did you have a question?
Go ahead. No.
All right. Thank you. That concludes the sentence. Thank you.
Judge, Your Honor,
Oh, 1 second. On Mr. Green, he has an open bench warrant under 24 FTA 712, and that's null cross and dismissed. Okay, that was it. Thank you.
Your Honor, position,
Ms. Najee?
yes, under probation revocation. She has a question, Your Honor.
Her attorney was Mr. McLean. Mr. McLean? Ms. Najee, is this a question about your bond, about your hearing
Yes,
date?
ma'am. Yes, ma'am.
What's the question about the hearing
I
date?
went to court on the 25th and they gave me a bond for those charges that I had. And I was just wondering if I can bond. I already bond out. I already paid my bond. So do I supposed to sit here or can I go home? Because I already went to court on all the cases.
What was that position number on the calendar?
Probation matter. So the probation calendar.
I went to court yesterday and they gave me a bond, Your Honor, which is already paid.
I'm looking up your jailing screen. So,
Hello, how are you?
so we've got this probation hold. And then she's got a cash bond on the felony charges.
Right, I spoke to one of the two attorneys. She has an unindicted matter and she's got one indicted matter. And the person I spoke to was speaking really to her knowledge of both, to the extent that she had knowledge of the one that was not hers. She was saying that mid to late August would be the time when everything's going to come together and get resolved.
Okay. I mean, I can continue with the probation hearing today if you want, but otherwise she has 2 counts of aggravated assault where she has no bond. So I'm not sure what bond she's talking about. Nothing's posted.
I had just paid my bond. I went to court for those aggravated assault charges yesterday.
You have aggravated assault, cruelty in the 3rd degree, and possession of a firearm or knife in which you have a $15,000 bond.
I paid the bonds yesterday. I'm supposed to be getting released through the bonding agency today.
You have 2 other counts for aggravated assault that have not been addressed.
It was addressed yesterday, ma'am. I went to court yesterday.
It's up to you. I mean, right now I don't see a bond for those 2 counts of aggravated assault. But Mr. McLean, you
$85,000 bond, which got paid yesterday.
Mr. McLean, it's up to you.
Well, if we put it on next week, Your Honor, we could get an update if there is an update. If the person I spoke to was not aware of that matter, if she made the bond yesterday, next week would take care of it.
All right, let me see. I have 23. SC 187202 and 24 PI 003971. All right, ACDC, please hold, and we will get back to a case in just a few moments. Miss Champion, no, who's my case manager? Is it Miss Grace?
Ms. Strong.
Miss Strong, could you look at these 2 cases? 23 SC 187202, 24 PI 003971. If you could ascertain the bond and if bonds have been made,
Can you
then
give
we
me
can
the
proceed.
second one again? The first one was 187202, correct?
Correct. And the other one is 24 PI 003971.
00. Say it again.
24 PI 003971.
Okay, give me a moment.
All right, courtroom 2, do we have another case to address?
I believe so, Your Honor. I believe these are first appearance clients.
All right, then we are moving on to our competency calendar. Everyone who is appearing for the competency calendar, please start your video so that the host may place us in a breakout room.
I'm gonna to, medical.
I think it's all over something starting.
Oh, sorry.
Mr. Bartel?
Yes, Your Honor, I'm here. There are some other folks here in the courtroom, so I'll need to go to medical and log on.
Let me know as soon as you're there. Thank you.
Judge Law,
Yes, Deputy Milton?
don't forget me.
I will not forget you.
Okay.
24 PI. She received a $5,000 straight bond. Oh no, this is a different case.
Which case is she in saying that she got?
I have 24 PI 003971.
So I see
The
He got a $75,000 bond on that one.
But if you look at the accusation number, it ends with 3978.
And that's the one she has the $5,000 straight bond on.
Correct. And that's under a different case number. And this present case.
Wait, do they just have the number wrong? Because
they do have the number wrong.
Okay, I just wanted to make
7-8, I still see a no bond.
So the wrong bond order is scanned up under the case.
There's 2 cases. There's
Right.
3. There's 7971 and 3978.
So
7978, I don't see a new bond order.
Seven,
they-
eight, Bostic, 7-8 is scanned up under 7-1, and the 7-8 on the bond order scanned up under 7-1 says 5,000 straight.
Correct. So, Mr. McLean?
Your Honor, it was my understanding on the PI cases, on the booking screen to the right, it shows the attorney's names. Princeton Hines represents her on the unindicted matters. Lisanne Edelman represents her and the one that is 23 SC 187202.
No, I'm just looking at her PI cases.
Right,
So she's got no bond in 24 PI 00. She has no bond on one of her aggravated assault cases. She's got two separate aggravated assault cases, and one of them has no bond.
Right.
So you decide what you want to do, you and Ms. Najee.
Well, Judge, so if you look up under both numbers, both of them are scanned with 7-8 under it. So I'm not sure
Right.
if she got a 5,000 on each one and they just didn't change the number. That might be something that he would need to inquire about, but
Yeah,
that seems to be the issue.
Okay.
all right. So we can move forward with the probation hearing today, or we can address it on the 11th. Her next court date in 3971, which I think is the case where she has no bond because the bond order is filed under the wrong case number.
Your Honor, she
Mhm.
has paperwork, indictment paper,
Look at the case number under the bond order.
22 CP 207286.
Okay. What about 24 PI 003971?
So Judge, under 7-1, under her other order says order to reset preliminary hearing is reset for 7/24 for absence of good cause. So I'm assuming that maybe they just didn't put the correct number on there like I was stating from the beginning.
All right. Mr. McLean, I can proceed with this probation hearing, but I'm not going to waste any more time about these incorrect bond orders that have been filed in felony court. That's something that Ms. Najee and her attorney in Superior Court have to resolve.
Right, we can ask to move with the current reset of the probation matter. Your Honor, we could ask to reset that and move it up if events warrant.
Okay, Ms. Najee, your bonds are not correct in one of your cases. You would need to contact your public defense counsel in your felony matters because you have not one, but multiple open felony cases. You understand?
Yes, ma'am, can I say something?
Sure.
I was told that my bond was $5,000 for one of my aggravated assault charges. And the other one, my other aggravated assault charge was $3,500 because the witness showed up. She dropped it to $3,500. I had an
I
paid.
totally agree with you if you receive a bond. I will agree with you. I just don't see it on the file. So I don't even have something to give to the jail to say release her on these bonds.
Okay,
So
I
right
call
now,
them.
my only question is, if you want to be released on the felony cases, that's up to the jail and up to Superior Court. The only question I have is, do you want to proceed with your misdemeanor probation revocation hearing?
I thought I had an attorney for that today. That's what I thought.
You do, Mr. McLean, and Mr. McLean is asking for a reset because of the mishmash in your bond issues. What would you like to do?
I don't understand because I don't have any representation right now.
Okay. Mr. McLean?
I mean, I do, but I don't know what he want to do, whatever he want to do.
All right. I'm going to reset the case to July 11th,
Understood.
unless you want to proceed with the probation hearing according to me, it seems that your client wants to proceed with the probation hearing.
I'm just going with it, with what the other attorneys told me, and I believe that, the 11th's fine. If it needs to be moved up or back, we'll certainly get hold of the court and.
Okay,
I haven't talked, can I speak with my attorney, please, before I
Do
make
it,
a?
right? We could do it.
yeah,
right.
you can speak to him anytime between now and
Because I thought
July
this,
11th. Thank you. Deputy Milton, I believe we've concluded. Ms. Champion, you can put whoever's on video right now in a breakout. And once Mr. Bartel joins us, we can please have him in the breakout. Take care, Deputy Milton.
Yes, I'm here, Your Honor. I'm ready to begin whenever
Excellent.
the court
Okay.
is.
Yeah, please hold. Ms. Champion will place us all in a breakout. Okay, courtroom 2, if we'd like to unmute, who do we have, please? Or South Annex, whoever would like to come on first? South Annex, please unmute. Who do we have?
Hodge Fowler.
Repeat.
Hodge Fowler.
Fowler,
Yes, ma'am.
Miss Vigilante or Mr. McLean, is that your client?
Yes, Your Honor, we have that down as a negotiated plea, but it's not holding him in jail. The attorney assigned to another courtroom wanted me to communicate to him that he thought something else could happen. If I could have the briefest of breakout rooms, even though there would be a problem with confidentiality because there's people behind me. I just need to communicate one thought to him really quickly from the other attorney.
All right.
See if you want to go
That's
forward.
fine, that's fine. Miss Champion, could you place South Annex and courtroom 2 in a breakout, please?
A.
South Annex?
Yes, ma'am.
No, I'm talking to the deputy there. Okay. Courtroom 2, okay. All right, folks, if we're still waiting. I have a Tamika iPhone. If you like to unmute and start your video.
Yes, hi. Yes,
Yes,
hello.
who are you waiting on?
This is his mother, Taj Fowler.
All right, please hold then until they come back. Thank you.
Okay. You're welcome.
All right, we will just be in recess until Mr. McLean returns. Thank you. Ms. Strong, if you have anything completed, you please email them to me, okay?
Oh, absolutely.
Thank you. All right, Mr. McLean, and we're just waiting on Taji Fowler to be removed from the breakout room. Ms. Champion, would you be able to close out that breakout room?
They should be coming back in now, Judge.
All right. Okay, Mr. McLean, Mr. Fowler has a 3,500 signature bond through pretrial services. It looks in both in his simple battery and in the Superior Court case. How would we like to proceed today? Oh, Mr. McLean, I think your audio is off, not connected on courtroom 2.
There we go.
Okay.
Your Honor, he'd like to do a negotiated plea today in the misdemeanor matter as the state is recommended.
Okay. Taji Fowler is accused of simple battery family violence from April 23rd, 2024 in case 24 CR 2169C. Mr. Fowler, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. May I place you under oath? Raise your right. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Ham, what's the recommendation for Mr. Fowler?
Yes, Your Honor. The state's recommendation is 12 months to serve 118 days, credit for the time served 64 days, balance to be served on probation, to have no further violent contact with Tiana Fowler, to complete a family violence intervention program, to complete 40 hours of community service, and to have no firearms on this person.
All right. Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
He does. For the purposes of the plea, we do.
Okay. Mr. Fowler, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with the legal services you've received?
Yes, ma'am.
And is anybody forcing you to enter a guilty plea today?
No, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or a jury. You would not be able to confront your accuser, challenge the evidence brought against you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
All right. We have Tamika's iPhone. Apparently, it's your mom.
Yes,
If
ma'am.
Miss Tamika would like to unmute and start your video.
Yes, ma'am. I apologize. I'm a truck driver, so I'm working.
Are you driving?
So I heard.
Are you driving?
No, I'm dropping a trailer. No, I'm dropping a trailer. I'm not like on the highway driving right now.
Is the car moving?
So
No, is the vehicle moving?
Okay, do you need me not to talk?
I need you
let me
to
ask
make
you
sure-
because
Let
you're
me
getting.
see both your hands on up.
Okay, so what I'm going to do is just let you do what you're doing. And I'm
Okay.
gonna mute and put the video back on mute, okay? Because
Okay.
I can't do that right now. I'm in the middle of dropping a trailer, so I can't just stop right now. I have to finish this.
Don't know what that means, but that's fine with me. Thank you. Please mute and
Right,
stop. the
okay,
video.
I'm just not on the highway or I'm not driving. That's what I'm trying to get you to understand. I'm on a safe lot where no one else is around me to hit nothing. So
Please
that's all
mute
I'm
and
trying to
stop
get you
your
to
video.
understand.
Thank
You said mute and start the video?
Mute and stop your
Is
video.
that what you just
please.
said, Jen?
Yeah.
Oh, okay.
Mr. Fowler, how do you plead to one count of simple battery family violence?
I plead guilty.
Your sentence is going to be 12 months to serve 118 days. Credit for time served, 64 days. It appears that you have 64. That would mean more than
That'll
18.
be time served because
That's what-
64 is greater than 50.
Oh, yeah, that's what I'm thinking. Okay.
You'll be up.
So, your jail time is concluded. So you'll be, if you have no other cases holding you at the jail, you should be released within 24 hours.
He
So-
does.
He does? Okay.
He does.
So upon being released from the Fulton County Jail, you will have to report to Fulton County Probation on the first available business day, which will be Monday, Tuesday, or Thursday. While you're on probation, you will complete a 24-week domestic violence program, and that you must enroll in that program within 30 days of being released.
Yes, ma'am.
You are to attend all 24 classes and make sure you complete them and present your certificate to the probation officer. You're also to complete 40 hours of community service at any nonprofit agency that is not a church and not a school, and it cannot be, it cannot be a church or school, and you must begin with completing 5 hours. Well, actually, you've only got 6 months left, so I'm going to require you to do 10 hours minimum per month,
Yes, ma'am.
10 hours every month thereafter. No weapons, no firearms. You're not allowed to own or possess any of these. And you're to have no violent contact with Tayana Fowler.
Yes, ma'am.
Okay. Any questions?
Yes. So I don't have to do any time, jail time?
Not for this case, but I don't know what's the situation with your other cases.
Yes, ma'am.
All right, that
Okay,
concludes the sentence.
Judge, may I ask a question, Judge?
Sure.
Now that I'm not moving?
Good.
Okay, you said he can't have any violent contact with his sister, correct? Is that what you're saying? I missed.
Correct. They can communicate, they can be under the same roof, but there cannot be any physical or verbal altercation. Otherwise, he's back in jail.
Okay, I just want to make sure I understood that because they live together. Okay, I appreciate it. Thank you.
Thank you. All right, Mr. Fowler, you're free to go. Thank you.
All right, have a great day.
You too. I think, do we have any other cases in courtroom 2? No?
No, Your Honor, apparently not.
All right, Miss Champion, I'm going to have you sound out the calendar. Let's begin with the probation revocation calendar.
It's gonna be Miss Strong.
Oh, Miss Strong, I'm so sorry. Miss Strong, are we good to call out the calendar?
Yes, ma'am. Give me 1 second, please.
Okay.
Okay, position number 1 was a probation violation, and position number 2 was to continue on probation. And position number 3, I missed the reset date because I don't think it's August 29th anymore.
Yeah, it's July the 11th. That's Naji.
Yes, ma'am.
Okay, on the add-on calendar?
Wait a minute, Judge, I'm going through all my calendars.
Okay, sorry about that.
Position number 1 on the add-on calendar was reset. I just put for the additional medical documents that you were asking for.
Yes.
Position number 2 was a negotiated plea. Position number 3 was null pros. Position number 4 was a negotiated plea. Position number 5 is reset for July the 9th. And I don't have what day we reset.
Position number 5, Chad Murray?
Correct.
Yeah, reset July 9th.
Okay. And I don't have Miss Owens. What day were we resetting her for?
I don't know. Miss Vigiletti?
She has been in custody for 4 months. If I could speak with her, we could get her out of here. So I would request as soon as possible.
July 11th?
Okay.
1 second. Okay, on the regular calendar, position number 1 was a negotiated plea. Position number 2 was null pros. Position number 3 was an amended bond, $1,000 good bond with the third charge, null pros. Position number 4 was a negotiated plea. Position number 5 was reset for July 2nd. Position number 6 was a negotiated plea with position number 1, null pros. Position number 7, 8 were negotiated pleas. Position number 9 was null pros. I don't have,
Dudley, what's the announcement on Dudley?
Your Honor, Mr. Dudley would like to enter a not guilty plea this morning, and it looks like he is waiving his presence and arraignment.
All right. The case is further notice for trial.
Position number 11 was a negotiated plea. Position number 12 was reset for July the 2nd. Position 13 reset for July the 2nd. 14 null pros. 15 and 16 were negotiated plea. 17 negotiated plea. 18 was null pros. 19 was a negotiated plea. 20 was null pros. 21 was reset for trial 22.
Yeah, for the notice for trial, correct.
I don't,
This is a waiver of arraignment.
for position 21, correct?
Yes,
Yes, ma'am. What is position 22?
Michael King.
Your Honor, Michael King, has been in custody for 97 days. Our office discovered, well, Paul and I discovered that no one had actually seen him from our office that entire time, because he refuses interviews. So we went up and saw him in person this morning before court. I did see him, but he refused to speak to me. The things he did say did not make sense. He was speaking, but it wasn't to anyone. I do think we should probably reset him to the competency calendar for an evaluation.
All right. If you are going to submit an evaluation order, please do so, and it's going to be reset to the July 11th, 11 a.m. calendar.
Thank you.
Position 23, Ms. Strong.
Reset for July the 11th, position 24.
Jonathan Mitchell. Ms. Vigilante?
Yes, I spoke with Mr. Mitchell yesterday. He's very interested in the possibility of participating in mental health court. It seems like a great fit for him based on the facts of the case. I did reach out to the solicitors. It was the evening to see if they would agree, and it sounds like we're just waiting on confirmation from Mom, who's the complaining witness, that she agrees that's a good idea.
Okay. On position 24, I'm going to reset it to July 11th at 11 a.m. 25. Ms. Strong?
Reset July the 2nd.
I'm sorry, Your Honor. I don't think he's a candidate for competency. He's a candidate for mental health court. He knows what's going on. I don't think he needs to be reset to 11 a.m.
Okay, then we'll just reset him to 9 a.m.
Yeah, thank you. And I know that the mental health court folks already know about him, so he may be transferred before then.
Okay. Position 25, Patrick Jacobs.
Reset SAP.
And we need a conflict attorney for him.
Yes, Your Honor.
Okay, can we reach out to Ms. McLeod and see if she will take the case? All right, position 26, Vincent Price.
It was an amended bond with a $2,000 split bond. 27 and 28 were waived arraignment, reset trial.
Okay, and just before, 26 was reset July 11th as well on his split bond.
For the 11th, you said?
Yeah, 11th.
Oh, I'm sorry, I do have that. Thank you.
27?
27 and 28, I have waived arraignment, reset further notice for trial. 29 and 30 were released, reset further notice. 31. What is
31, do you have an announcement? Tequila Smith Wilcox. Oh, Ms. Atay is asking for a 1 week reset, so we can reset it to, right now, the only reset date we have is July 9 full up?
I had that Latrice Shelton would be reset to July 9th because she was in another court.
I thought we were on Smith.
And that's position 28 was reset to July 9th, and then Smith Wilcox also reset to July 9th.
Okay, it was position Latrice Shelton is reset to July 9th. Okay. Let's change that. Position 28 is reset to July 9th. Position 29 and 30 are released further notice for trial. That's Shamika Smith.
Oh, yes, that's right.
Okay. So then brings us to 31, Tequila Smith Wilcox. You're asking for a 1 week reset.
Yes.
31 and 32. I have July 9th or July 11th, but I don't know what's the status with July 9th. Ms. Strong?
Give me 1 second, Judge.
Okay.
July the 9th. We got to do the 11th. Has to be the 11th.
All right. Smith Wilcox, positions 31 and 32 are reset to July 11th. Moving on to position 33, Javian Stevens. That was a waiver of arraignment and further notice for trial.
with an amended $2,500 good bond.
Yeah.
34 was reset for July the 9th.
And Mr. Dennis Murphy is been appointed.
Correct. And I don't have anything for, 35 and 36 was released.
Right, so they're both further notice for trial. Okay. Calvin Williams, 37 and 38, I've got a waiver of arraignment and further notice for trial. Ms. Vigiletti, would that be correct? Or Ms. Atay?
That's
That's
correct.
correct.
And on position 37, signature bond through the jail under.
$1,000 signature bond to the jail. And position 39 was waived arraignment, reset jail jury.
Yeah.
For trial.
No, that
For
was
trial.
Ricky Williams, correct?
Correct. And can PDs, can you please send your orders to Ms. Strong?
Absolutely.
Thank you.
Okay. Mr. Ham, did you have any questions about the calendar? No? Okay. Ms. Vigiletti or Ms. Atay or Mr. McLean, any questions?
No, Your Honor.
All right, Ms. McKechnie, we good? All right.
Yes.
You all enjoy the rest of the afternoon. Unless for those for the expedited accusation calendar. Take care, everyone. Bye-bye.
Thank you.
Thank you.